Participants, I hope you already logged in. Thank you very much for sparing your time and joining us today. We're going to start with a word of prayer, and I would like to request Mabel to open today's session with a word of prayer.
Thank you, Doreen. Thank you, Agatha. Sorry. Let's humble ourselves for a word of prayer. Father, we thank you for this day. We thank you for this time. Lord, as we gather and deliberate on international trade and investment, I pray that you will guide us, give us wisdom, open our eyes to the opportunities that the free trade area presents for us. Lord, I pray that the deliberations will be smooth and this will be a learning step to the next stage of our practice. I pray that you will guide us and guide everyone that is here. I pray that those that are coming, I pray that you will quicken their footsteps so that they'll be able to join us and start the deliberations. In Jesus' name I prayed.
Thank you, Mabel, for that prayer. We're just going to stand up for the national anthem.
Afrika Mashariki, tuwezeshe kuishi kwa amani, tutimize na malengo yetu. Jumuiya yetu sote tulilinde, tuajibike, tuimarike, umoja wetu ni nguzo yetu, idumu jumuiya yetu.
Thank you. We can have our seats now. Once again, thank you for coming. My name is Nisima Agatha from Kampala Associated Advocates. And this morning I'm privileged to have my boss here with me to give opening remarks for today's training. This training has been possible in collaboration with Uganda Law Society, in collaboration with Kampala Associated Advocates and the University of Portsmouth. So Mr. Joseph Masiko, you're most welcome. And I request you to make your opening remarks.
Thank you. Thank you, Agatha. Good morning, everyone. Good morning, ladies and gentlemen. My name is Joseph Matsiko. I'm the managing partner, Kampala Associated Advocates. I would like to welcome you all to the International Trade and Investment Law training. I am pleased to be with you to consider some basic WTO principles, dispute resolution under WTO and CFTA, the future of trade and investment in Africa, and the role of lawyers in international and regional trade and investment transactions. As we get more insight in this area of practice, we hope to understand the challenges for free trade and investment in our region and to explore opportunities for lawyers in this space. The benefits international trade and investment have brought Africa should never be taken for granted. They have powered growth and lifted millions out of poverty. The clients lawyers represent include governments, merchandise and service traders. Many are considerable sources of foreign direct investment. As with any development comes challenges. Therefore, we shall inevitably see international trade tensions increasing. And as challenges emerge, the role of the lawyers is inevitable to advise governments and private individuals and entities on how to deal with these obstacles. Ladies and gentlemen, as we look towards the future, we as lawyers need to be intentional on educating ourselves on the regional, bilateral, and multilateral agreements, such as the ESC, COMESA, the AFCFTA, the dispute mechanisms under the WTO and AFCFTA, to fully exploit opportunities in existing agreements and to deepen trade integration in our region. Today, we are very honored to have our main speaker, Professor Leila Shukron, from the University of Portsmouth, University of Portsmouth, UK, together with your colleague, as well as a panel of Ugandan legal practitioners to provide an insight on the emerging issues in international trade and investment law in our region. As KAA, we are proud to be part of this training and proud to be partnering with the Uganda Law Society and Professor Shukron. And we implore all lawyers present to take lessons to better position ourselves to benefit from the opportunities arising from international and regional trade transactions. I would like to wish you all a very successful training for God and my country.
Thank you so much, Joseph. Let's give him another hand of applause. Yes, once again, for people attending online, please make sure you're logged on because the event attracts CLE points, which we all need. I would like to take this opportunity to welcome the president of the Ugandan Law Society, who is here with us, Mr. Bernard Owundo. Let's welcome him as he comes to give his welcoming remarks.
Good morning. Good morning again. Let me also greet those who are online. I think COVID has taught us that we can do some of these things online. So we have those attending online. I want to take the opportunity, first of all, to welcome all members of the Uganda Law Society to this very first physical training of CLE for this year. So welcome. I also want to thank first and foremost Kampala Associated Advocates, led by the managing partner here, Mr. Joseph Masiko. I almost called you doctor. I think it's high time you start studying a doctorate. Mr. Joseph Masiko here. So thank you, Kampala Associated Advocates. Let me also thank Mebo. I think the firm is called Mensa, right? Yes, Mensa Advocates, for also participating in building, in coming up with this training. Let me also thank our professor, Professor Leila Shukron. I hope I've pronounced the name right. You'll forgive us, some of these names may be a little bit difficult to pronounce. And the University of Portsmouth. Let me also take the opportunity to thank you for collaborating with us. The managing partner has informed us about the benefits of this training. But I just want to share for me, numbers don't lie. Look at the population of East African community. We are now about 475 million. If you look at the population of the African Free Continental Trade Area, it's about 1.3 billion. And I think the GDP for the African Free Continental Trade Area is $3.4 trillion. Now, for me, numbers don't lie. If you look at the potential of the African Free Continental Trade Area, then you can see what we as lawyers are supposed to be doing. We are supposed to be following the business. If you have a GDP of $3.4 trillion, I wanted to compare with our Ugandan GDP, but perhaps on another day, just to show you what we are trying to discuss here. So as the Uganda Law Society, our belief is that we must be able to follow opportunities and guide our members towards building their capacity so that they can be able to harness these opportunities. And as the Uganda Law Society, we are able to collaborate with other partners because of our umbrella organization that has almost 5,000 lawyers. We also believe that one of the areas in which our members should obtain training is, of course, international trade and investment law, which my senior colleague has highlighted some of the issues that will be discussed in this training. This session, therefore, is designed to train lawyers on the basic principles of the World Trade Organization and the Africa Free Continental Trade Area, dispute settlement under the WTO, the future of trade and investment in Africa, and the role of lawyers in international and regional trade transactions. We expect that once you get this training, you will be able to advise on some of these transactions happening in the region. But this training should also give you a foundation so that you can be able to trust yourself in this area and go for further training. Recently, I had a meeting with the AG and we were discussing opportunities for lawyers. And one of the things he was mentioning, he was saying, if you want opportunities, give me a list of people who, for instance, practice international trade and investment law. This is the direction we are taking. It's just not enough for us to ask for opportunities. We must build the capacity. As someone once told me, it's not just about local contentment, that as local people, we are happy. So we are happy that at least opportunities are coming for us. We must deliberately build capacity. So I believe that this training will help us build that capacity. And so as Uganda Law Society, we're going to take the next step. One of the next steps we're going to take is to launch the International and Regional Trade Law Cluster. And we are going to see how the ESC cluster that we have currently is going to work with the International Trade and Regional Trade Law Cluster. We are going to see how we can harmonize so that we have one cluster for international trade and investment law. So I'm going to appeal to all of you who are interested, because this cluster, we could have put out a call, but we're now adding another twist to it. All of you who are interested, please show your interests. I think the Secretariat will share an email where we shall be able to share. So I'm going to ask all of you to be able to join that trade. Lastly, I have thanked Kampala Associated Advocates. I have thanked everyone here, but I want to thank the young ladies, Agatha, Mabel, Sophie. I don't know whether were you involved or the law firms. I want to thank them personally for taking this initiative. My belief, my philosophical belief is that your candle can only shine if you shine other people's candles. So I want to shine a light on these young ladies for pushing and ensuring that we actually form this cluster. For me, the future is with people who will look at the opportunity and then be able to strategically push for it. So I want to thank you on behalf of the Uganda Law Society. Let me recognize you for your efforts. Thank you for being able to assist us bring this training to our members. Thank you again. And I think I'm supposed to I therefore open the training, but I think I'll have to invite, what does the program say, Agatha? I'll have to invite the professor to come and take us through. I'll be here for a short time, but I'll be following online also. Thank you. Thank you so much.
Thank you so much, Mr. President.
A very good morning, everyone, whether you're here physically or online. I'm absolutely delighted to be with you this morning. First and foremost, I'd like to express my sincere gratitude to the Uganda Law Society and its president, as well as KAA Law Firm, represented by Mr. Joseph Matsuko, who's here today with us. Thank you very much for organizing this training. As the president of the Law Society just explained, we have conceived this first training as a foundation, really, to give you some keys to embrace the journey of international trade and investment law, which is a fascinating one, a complex one, a technical one, but certainly a very useful one for your firms, for your practice, knowing that this area is very much emerging in Africa and getting stronger and stronger everywhere in the world. Before I start, I would also like to express my thanks to Agatha and Embo, but also Tony Kirabira for supporting us to organize this training session with you this morning. So I'm very grateful to be here, and I hope you'll be as passionate and as interested as I am about international trade and investment law indeed. So we are going to start together for about an hour and a half of general discussions and foundations again on what exactly is international trade and investment. Feel free to interrupt me if you have questions. I've sent the presentation to your colleagues, so you might have received it. If not, you will receive it, and I'll send you additional materials so that you can work together. So the way the session is going to organize, we have this first an hour and a half, me talking you through all the meanders of international trade and investment law. Then we'll have a break, I think, a panel discussion with some guests, including a gentleman from the Ministry of Trade. And then we'll have a sort of more interactive session around 2 exercises so that you can engage and try to apply as much as you can what you've just learned about international trade and investment law. So I'm conscious that we have a number of you online. So for the colleagues online, it might be slightly more difficult to interact. However, there is a chat, I suppose, so feel free to ask a few questions on the chat. I can't see the chat now, but I'm sure our colleagues are going to convey the messages and the question to me whenever they can. So feel free to also ask questions if you're online. All right, do you have any question before we start or any remarks? No? So let's go. So why international trade and investment law matters? That's exactly what we're going to try to demonstrate today. So let's move to the next slide, indeed. How to define international economic law. So without looking at that, maybe we move up to the previous slide, if you don't mind, to the title. Can you move up to the previous slide, the title? No, the previous one, exactly. So without looking at my other slide, how would you define international economic law? That's it, you're on the spot, I'm not talking anymore. Any idea? How would you define international economic law? Hopefully you don't have my slides in front of you. Any idea? What does it cover? The title might be confusing. Just throw a few things at me. It doesn't matter whether you're right or wrong. We're not judging anyone. So international economic law, what can it cover? Something economic, probably? Yes, go ahead. A courageous gentleman.
I want to believe international economic law covers, the norms that govern how either states relate with each other in terms of economic activity, and even individuals against states, or states against states, or states against individuals. That is really my layman's thinking about.
That's perfect. It's going to be difficult for your colleagues to add up on that because you actually capture a lot of things. Sometimes it's confusing because people think, oh, we're talking about the economy, so it must be private. But indeed, international economic law, the state is at the center. So this is indeed how economic relations are governed between the state and another state. And to some extent, when we talk about international investment law, a state and a private party, and obviously in trade as well, you have a number of private interests. So can we move down to the next slide? Thank you. So how to define international economic law? What does it comprise? What does it cover? Is it public? Is it private? Is it very diverse? Who are the subjects of international economic law? Its actors, its recipients. So show you make a difference between the subject, the states, the actors, private companies, and us individuals. And recipients, you can have plenty of different recipients, including, for instance, NGOs. Is it fragmented? Is it not fragmented? Who benefits from it? So international economic law has long been defined as the law of international economic relations among states, exactly what your colleague said. It is rooted in general public international law. That's something extremely important to bear in mind because when you practice trade and investment law, the background is public international law. We're not in the private sphere. And this is something which is often lacking. Lawyers practicing international investment arbitration very often have a private law background, which is very tricky because they are actually dealing with the state. So it's not private law, but it's public law. And yet, with the development of international economics, the economy, decolonization, globalization, international economic relations have evolved. They've become extremely complex. And indeed, you have this sort of mix between the private and the public. Next slide, please. So these interactions shape and question international economic law in its foundation, its ability to adapt and provide legal tools to tackle contemporary issues. To name just a few actors, and I'm sure you've probably interacted with them, we can name the World Bank, the International Monetary Fund, the World Trade Organization we're going to discuss together today, and a number of regional structures like the European Union, and why not now, the African Continental Free Trade Agreement, which is probably the longest abbreviation and always a mouthful. So that's what we have. Then international economic law, to simplify, is indeed the law of international economic relations with the state as the primary, but not the only subject and actor. Really, this is simple, but always something to bear in mind if ever you have to practice these fields. It encompasses a vast array of specialized topics from trade, investment, finance, development, and aid. It is, however, coherent if approached as a component of general international law, resting upon the same principles as international law: sovereignty, equality, pacta sunt servanda, good faith, peaceful settlement of dispute, and so on and so forth. And the sources of international economic law, as well as in general international law, are outlined, as you may remember, in the Article 38 of the Statute of the International Court of Justice. Tell me, why is the principle of sovereignty very key in international trade and investment law? Go ahead.
I think because the statute told us that international economic law is dependent on international law, and sovereignty is one of the biggest principles in international law.
I think that's absolutely right. And could you give me a practical example, maybe something you came across in your own practice, showing why sovereignty as a general principle of international is so important in trade and investment and in international economic law generally? Very practical example.
The provision relating to the law that will determine if you have a dispute, the applicable law. applicable law, which could be the law for the state in which the dispute is happening or the trade is happening.
That's excellent. So sovereignty at the center of our discussion, because if, for example, if you have a dispute between Uganda and Kenya, you're going to look at possibly bilateral investment treaty, but also at national laws. And indeed, sovereignty matters a lot. Okay, so we'll have many other examples, but that's the idea. So, you know, I just want to show you something to tell you that indeed, international economic law is quite complex. I've written together with my colleagues, Professor James Nejupara. So it's a sort of shameless self-promotion, but just to show you, you know, that's what international economic law covers. Written together this book, 850 pages. So today we're not going to summarize 850 pages, but at least give you some idea. Trade and investment are very much part of international economic law, but there are so many other domains actually. Development and aid, finance. Some would integrate competition law. I wouldn't, because I think it's quite different. But surely development and aid, the work of the World Bank, the IMF, and so on and so forth, and indeed international finance, which is getting more and more complicated. Right, let's move on. To summarize, there are a few international economic law and international trade law, to be more precise, basic principle. Non-discrimination, most favor national national treatment, MFN, most favored nation, yeah, and national treatment. So again, without looking at my slide, can you tell me what this non-discrimination principle covers? Although you have an idea in simple terms.
If a country makes a concession and a tariff is given or is reduced, it applies to all countries equally. So it cannot apply to Uganda alone, and it has to apply to all the countries. Yeah.
Absolutely right. You have the idea of equality somehow, and when we talk about tariffs, right? So any other comments on the idea of non-discrimination? What can it cover? Of course, I'm going to explain that in great details, but it's really central. It's key in trade and investment to understand what we're talking about. Non-discrimination. Maybe give me a practical example, something you came across in your practice. In another field, maybe not necessarily trade and investment, but it's true that it's key in trade and investment. Ambo gave us the idea of a tariff, which could be applied equally everywhere in the world. What else can we have? Yes?
I think, for example, in the ESC, there are a lot of sensitivities. You cannot, for example, provide either excess duty or a tax on particular goods from Kenya, and then, you know, from either Rwanda or Tanzania, you make them slightly lower. But then you make other people, other countries more, non-competitive as compared to their neighbors.
Yeah, very, very good example as well. Excellent. So let's move into the details then. Oh, sorry. And here we are. So non-discrimination, as you understood, is a key principle found in almost all branches of international economic law. It includes principles such as the most favored nation treatment and the national treatment. So generally, people are very confused. Well, actually, these principles are extremely simple. If explained in simple terms, they often confuse MFN and national treatment. Let's start with the most favored national MFN, the most favored nation treatment. Under the GATT, which was the predecessor of the World Trade Organization, as you know, it is the obligation to extend, and I'm quoting the words, to extend any advantage, favor, privilege, immunity granted by a WTO member to any product originating in or destined for any other country immediately and unconditionally to like product originating or destined for any other members. Very simple, and yet you have so many different little criteria which can be really problematic. And this is precisely what matters if you practice trade. And if ever you have to advise, let's say Uganda in a dispute against another country at the WTO level or in the future in the context of the African Continental Free Trade Dispute Settlement Mechanism. So let's look at that. To extend any advantage, what's an advantage? Favor, what's a favor? Privilege, what's a privilege? Immunity, granted by a member of the WTO, let's say Uganda, to another member, let's say Tanzania, or product originating, coming from, but again, what does it mean? Or destined going to for any other country. And then you have a number of other terms, unconditionally, so that's a bit tricky as well. To like products, you have a plethora of disputes telling you what's a like product. Is beer like wine? You're going to tell me, of course not, because beer is beer and wine is wine. But I can tell you, yes, but it's alcohol. So is it like? Is, I don't know, maize like rice? Of course it's not, because it's maize and it's rice. Yes, but maybe it's consumed for the same reasons, you see? So you can go deep into this type of argumentation. Right, so we'll go into a few examples so that you understand. It's absolutely key to understand this principle of MFN, which is at the center of all the trade and investment architecture. Slightly different in trade and investment, but maybe I have time to go into the details. National treatment is slightly different, but also related. National treatment seeks to ensure that WTO members do not treat imported products less favorably than domestic products once the products enters the internal commerce. The purpose of national treatment is that no indirect production is given to the domestic production. Right, can you challenge that? Do you think it happens all the time? First of all, did you get what it means? And does it happen all the time? So the whole idea is to seek to ensure that the WTO member, but it's the same with the African Free Trade Agreement now, do not treat imported product less favorably than domestic product. Does it happen all the time? Give me example exceptions. Are there possible exceptions to national treatment? Do we always treat imported products the same way we treat our national products? No. Why, you think? Yes.
Thank you. Usually here we treat imported products to be of much better quality as the domestic product.
In terms of that, that's a good remark. But you mean you would favor imported products? Maybe. And how, technically speaking? So that wouldn't be a breach of the national treatment, but yeah. You would give preferential access to imported products? Maybe. But what happens generally is a bit the opposite. Don't you protect certain products as well?
No, I think in reality, whereas we talk about, treating all products across, for example, from the East African community equally, I have come across instances where, Ugandan cement manufacturers try to block imported cement, or cement manufacturing material like clinker, which is quite cheap out there, just to try and support the local industry. Then we have policy. There's the Buy Uganda, Build Uganda policy, which is also ruffled a bit of feathers because the neighboring countries say, it's against the ESC protocols.
Again, excellent example. You all remember the slogan, some sort of like America is great, Buy American, probably you may have Buy Ugandan, you see what I mean? Because many governments everywhere in the world also want to protect their domestic industries. So there are exceptions, and sometimes very justified exception to national treatment. So you would treat better, in your example, cement, because you want to grow your national industry. Right. So these principles are not necessarily absolute, right? MFN is slightly more absolute than national treatment, if you wish. National treatment, you can have a series of justified exceptions. And these exceptions very often are listed. I give you an example, services, the trips. You know that we trade not only in goods, but also in services, for instance. Are legal services open in Uganda? No. So it means that you can't have a firm from France, the UK, or I don't know, China to open up here a boutique law firm or a big law firm because the services are protected. So in this case, you're not really implementing national treatment as such, but you're not either breaching the WTO, you've probably listed in your what we call schedule of concession, a number of sectors that you don't want to open. Very often, legal services are not open. Sometimes very strategic services like military, defense, sometimes also communication, certain technologies are not open because, again, the states want to protect the growth of its national market, or sometimes also because it's strategic, right? You have national interests that you want to protect. Another very interesting sector, which is open and not open, it depends on the will of the countries, is education. Do you have in Uganda international universities or foreign universities which have open branches here? Maybe a few. So it might be that education then is open. So you see, tricky, very much the devil's into the detail. So you have to check sector by sector what your government has agreed or not to open. And this is really interesting in terms of investment in particular. Okay, so I guess you understood the main principle, but these are relatively simple and yet at the same time have created a number of disputes. And when I say a number of disputes at the WTO, probably the 600 plus disputes all have a component of MFN and national treatment, really. So to get into a few details, less favorable treatment under the Article 3 of the GATT has overwhelmingly established the basis of the impact of the treaty. You also have a separate regime in the investment agreement within the WTO. And you have a few exceptions, for instance, the enabling clause, which is considered as an exception to the Article 1 of the GATT. And it enables members to provide preferential, non-reciprocal, and more advantageous treatment to products originating from developing and least developed countries. Again, something really interesting to look into, but don't necessarily have the time this morning. The WTO has its own sort of rules for exception, in particular for developing countries, in particular for agricultural products. Let's move on. Article 1 of the GATT, the most favored nation treatment, just to give you an example, with respect to custom duties and charges of any kind imposed or in connection with importation and exportation or imposed on the international transfer of payments for import and export, and with respect to all matters referring to in paragraph 2 and 4 of the Article 3. And then you remember, I quoted that already. Any advantage, favor, privilege, or immunity granted by any member to any product originating in or destined for any other country shall be accorded immediately and unconditionally to like product originating in or destined for the territories of all members. I invite you to obviously look at the website of the WTO. It's very, very well made. You have everything you can look for. Then, of course, it's complicated technically, but you have absolutely all the resources, all the disputes, and very often you also have some sort of notes explaining disputes, the most important one, short courses, and so on and so forth. MFN principle, the enabling clause, I think I've just discussed that. Let's go a bit further, maybe, because we have quite a lot to cover. So if you look at the WTO treaty, or maybe before I say I explain that to you, I'm going to ask you a few questions. So tell me, the WTO agreement, so we're talking about the World Trade Organization, from what you know already, what does it cover and how does it work in terms of treaty? What does it cover exactly? So we said already trade in goods, but what else? Services, intellectual property, disputes, absolutely.
Dispute mechanism.
Dispute mechanism, excellent. Any other area? agriculture. What else? Excellent. Sanitary and phytosanitary measure, technical barriers to trade. Right. So you've heard probably about all these, different agreements. So it's a sort of, let's use a term which is very often used in the WTO sort of dispute settlement, chapeau. So it's a box. It's a box within which you have several agreements. The WTO itself is an agreement, and within that you have an agreement on agriculture, an agreement on services, an agreement on intellectual property, another one on agriculture, another one on technical barriers to trade, another one on sanitary and phytosanitary measures. Again, all these agreements are extremely technical, regularly negotiated through rounds of negotiation that you've heard about. The last one being the Doha round for development, which has never really been concluded because of tensions between countries. Recently, some improvement in agriculture and the conclusion of a deal on fisheries, which is really interesting, and I invite you to take a look at because it's quite relevant for Uganda. But yeah, that's how it works. Within these agreements, and in particular the one on trade in goods, so the GATT, you have the question of tariff, quotas, and indeed preferential trade agreement. Tariffs are tax imposed or on imported commodity. They may be imposed for a variety of reasons, including revenue for the importing country, coercion, or to protect infant industry. Surely you have a number of tariffs on a number of products. These are listed clearly by the Ministry of Trade, I imagine. These tariffs are binding, and they seek to preserve the value of tariff concession negotiated by a member with its trading partner during the Uruguay round of the GATT negotiation. Specific commitments, this is what we were discussing before, are listed in what we call schedules of concession, which reflect specific tariff concession and other commitments that members have given in the context of trade negotiation. We alluded before to the schedule of commitments for services, for instance, education, law, legal services, etc. We also have other restrictions, what we call quantitative restrictions. They refer to non-tariff border measures which are applicable of impeding trade directly or indirectly, actually or potentially. They are not permitted either under GATT or the agreement on agriculture, but under certain specific circumstances. So we're getting into very technical details, but that's good to have that in mind for now. A WTO member may maintain this quantitative restriction to avert a balance of payment crisis. So when you have more, in fact, importation than exportation, as you guessed very well, or under certain limited exception under the Article 11 of the safeguard provision under the Article 19. WTO members are permitted to form custom unions. So what we call custom unions are these regional agreements, in fact, and you have plenty in Africa. You have ECOWAS, now you have the African Free Trade Union. So it's very much permitted under the WTO, as long as the conditions to enter into economic integration agreements are met. Such arrangements constitute an exception to the MFN principle under the GATT. Because you remember I told you, you have with regard to the MFN to give to, let's say, Kenya, the same thing you give to Germany, okay? But in fact, you have the regional exception. So this becomes extremely much more complex if you look at what you can actually do in this given region, because you derogate somehow from the MFN principle in a regional integration. You got my point? Yeah? Excellent. Let's move on. Preferential trade agreement in goods are permissible under the GATT once this agreement is comprehensive and includes substantially all trade, and that the liberalization does not result in higher or more restrictive duties. And you can implement this preferential agreements in which you have, in particular, a number of provisions on the rule of origin. Well, extremely technical, not really much time today, but again, foundation, you have these general ideas in mind. Good. WTO members are obliged not to exceed their applied tariff on goods beyond their bound levels, and WTO panels and the appellate body have examined members' obligation under the Article 2 of the GATT in several disputes. For example, just to give you an example, the Argentina textile apparel, in which Argentina maintained minimum specific import duties on textile, apparel, and footwear, which had a bound rate of 30% and was just challenged. So it's, as you guess now, and probably you knew this before, trade and investment are extremely specialized and extremely technical. So much so that in most trade departments in the world, you have experts not only on trade and investment, generally speaking, but experts on quota, experts on anti-dumping, experts on subsidies, experts on TBT. So in a way, it's very costly, if you wish. It's costly to invest in this field for governments and to some extent for law firms as well. But I'm sure progressively, as a practitioner, you can find your niche. So you can be a trade and investment expert, but you can be a super expert of subsidies. That's what I'm trying to say. I'm sure you knew that already, but we're getting into more technical details. Right, let's move on. I'm presenting actually all the WTO agreement in a nutshell. Really, we don't have much time, but I want you to have a general understanding. Any question before we go into the agreement on agriculture? Not yet. We have about 1 more hour. You're not exhausted, I hope. And I don't see people online, but I hope they're still following as well. So let's move on. Agreement on agriculture. That's one of the most interesting and somehow one of the most complex and certainly debated agreement, because it's at the core of many economies, not necessarily because it brings a lot of revenues, but also because agriculture is quite symbolic. It's also the sort of fabric of a nation, the identity of a nation, of some people. What you eat is also what you are. That's one of the reasons the agreement on agriculture is so complex and somehow so much debated. So as I said, it's a very sensitive sector and has been one of the most contentious areas of international trade. And this is certainly the most difficult to negotiate at the moment. So there are 3 pillars in this agreement: market access, domestic support, and export competition. Market access, domestic support, and export competition. Without looking at that, what do you think these covers? Let's start with market access. What can it cover? Market access. So we're talking about what? It's logical. Are you in this country? Are you authorized? Are all agricultural goods authorized to enter Uganda? No. It's the same, I believe, everywhere. So whether market access, whether, I just make a story, whether rice from India is authorized to enter this particular market, right? Or the other way around. Domestic support, what does it cover?
We have a comment online from.
Oh, sorry. Yes.
We have a comment online. I don't see the name, but it states local products are treated more favorably. For example, sugar. If you import sugar, you will pay a high tax. The idea is to discourage importing sugar.
That's it. That's it. Indeed. Indeed. As we were saying before, you have the encouragement, or you have certain ways to protect your own domestic production in agriculture or industries. So indeed, domestic support, to get back to that, we're talking about somehow what we refer to subsidies. So a number of sectors in all countries are subsidized, which is authorized. And again, we'll get into some sort of details a bit later. And export competition, what could it be? What can it cover? Export competition? Is it easy to export? Not necessarily. So sometimes the state also helps exportation, but that's tricky under the WTO. Okay. As part of the market access commitments, members were required to convert all their non-tariff measures into tariff equivalent. In addition, the tariffs were subject to a reduction commitment over a period of time. Members are permitted to impose a special safeguard duty on selected products subject to meeting the volume or price triggers specified in the Article 5 of the Agreement on Agriculture. Under the export competition, members were permitted to reserve the right to provide export subsidies, as I told you, to help export if you wish. However, these were also subject to production commitment. These export subsidy discipline in the Agreement on Agriculture are different from the provision of the subsidies and countervailer measure agreement. Super complex, but you have a general idea. So the discipline on domestic support is one of the major contributions of the Uruguay round. It's based on the effects of the subsidies on trade distortion. We shouldn't distort the market. And you have a series of side rules, if you wish, which are referred to often as amber box, blue box, green box under the Agreement on Agriculture, targeting specific negotiation to very much simplify. The green box subsidies have no or minimally trade distorting effects. The concept of domestic support is captured by the aggregate measures of support. These AMS were subject to reduction commitment. Measures subject to AMS calculation are termed as amber box subsidies. And also direct payment associated with production limiting programs, blue box, are excluded from that. De minimis provision for AMS permits exclusion of product-specific and non-specific support not exceeding 10% of respective current output value for developing countries. I'm sure I've lost you. It's absolutely normal. The Agreement on Agriculture is extremely technical and needs, you know, some sort of special training for a few weeks because it is difficult, really. And you have only a few experts in ministries or in firms working on that. And one of the criticism actually from developing countries in particular is that we just can't deal with it. It's so complex, so technical, so many different details that we do not necessarily have the expertise, not the intellectual expertise, but the sort of manpower to deal with all these requirements. Unfortunately, at the same time, a number of developing countries are essentially exporting agricultural products. So they find themselves in a very tricky situation, not necessarily having the manpower or women and manpower to address these technically hyper complex issues. Well, in fact, they should, because that's the main export that they have. And together we will look at the African Continental Free Trade Agreement. You also have a section on agriculture, which is not very far from the WTO. So these have to be better understood. And as much as you could, I'm sure you have really a few firms in the country specializing on that, but build up capacity very fast to be able to address these technical issues. Let's move on. So you have plenty of cases on agriculture. One of the most famous case is the EC banana, one of the most famous WTO case. It was a case, a complaint brought by Ecuador, Guatemala, Honduras, Mexico, and the United States against the European communities on the banana regime. The EC had operated a complex regime, including the use of tariff rates quotas on banana imports from third countries. The complainant, challenged the country-specific allocation of tariff quota shares to the African, Caribbean, and Pacific and the Banana Framework Agreement. Countries were inconsistent with the tariff quota allocation under the rule of the Article 13 of the GATT. And it went on for years and eventually it was settled. But for those of you who've come to Europe, you may have noticed that we mostly have bananas from the Caribbean. Because of this, because, you know, you have a preferential regime somehow for bananas from the Caribbean and not for those coming from other regions of the world, and in particular Africa. And I'm very sad about that because I much prefer African bananas. And that's the reason, indeed, you know, these exports are blocked. So you had this complaint by other members, etc. So you see, that's what WTO is about. Very specific, technical, niche discussions. Now, another one, also extremely important for countries which mostly trade in agriculture. And of course, you're not going to trade in agriculture forever, but you know, at the moment it's something important. Technical barriers to trade and sanitary and phytosanitary measure. The agreement on technical barriers to trade, TBT, and the agreement on sanitary and phytosanitary measures seek to discipline behind the border regulatory measures. Very interesting. So what can it cover without looking at the SPS and TBT? We're talking about behind the border measures. It's not quotas, it's not tariffs, it's not before, but behind the border. Sure, I'm sure you're, without being specialist, I'm sure you're relatively familiar with that. Behind the border measure, TBT, SPS. What can it be? Yeah. Yeah. Exactly. Exactly. Exactly that. So we're talking about, again, technical requirements, which have to do with health and sanitation. So it can be a particular pesticide, or maybe this banana has to be this shape, or this orange has to look like this and that. And you see what I mean? So again, extremely difficult, but and it has been argued for decades by developing countries that they couldn't meet these standards, and these standards were de facto harming their trade and de facto barriers to trade. The World Trade Organization has organized plenty of trainings everywhere in the world about these measures. The TBT and SPS agreements aim to discipline unnecessary barriers to trade through harmonization. So that's the key word. Let's harmonize our system. Equivalence and conformity assessment procedures. Both the agreements include provision for addressing disguised restriction on trade while safeguarding the interests of WTO members for pursuing legitimate regulatory objectives. While the TBT agreement focuses on non-discriminatory aspects, the SPS agreement highlights the rules of science and the need for conducting risk assessment. Both the TBT and the SPS agreement play emphasis in exploring measures which are least trade restrictive. The SPS agreement includes a special provision on regionalization to ensure that SPS measures do not disrupt trade from areas or parts of the country which are disease, pest, or risk-free. Participation in international standard-making activities is one of the recommended ways of achieving coherence, uniformity in domestic standards, and both the TBT and the SPS place emphasis on timely notification and information exchange. So that's really interesting, because in SPS and TBT, to some extent, you have a margin of flexibility and information and discussion. So you may say, well, your whatever orange cannot enter my country because we've just put in place this new measure, but we're happy to explain that to you. There's a margin of flexibility. Here are the criteria. Science changes as well. So you may accept oranges because of this and that scientific elements, and maybe in 2-3 years, you've changed your reasoning, yeah? Okay. Do we have a break now, or do we have 5 minutes? Do you want to take a break now? Yes. So again, I think we have a short break, then we go back and we move on to anti-dumping and many other different things. All right.
Thank you, Leila. We are just going to take a short break and have some tea. It's going to be a working tea, so you can pick your tea and get back to your table, and then we continue with the training. Yes, our
online participants have a tea, and we'll see you in what, 10 minutes?
Yes, in 10 minutes. Please, that is at the back.
is a number of colleagues, then a mini break, and then we'll try to do some exercises together, simple exercises to conclude our session. So before we took this break, we were talking about dumping, or rather anti-dumping. So as usual, I'm going to ask you a question. Dumping is a popular sort of term. You know, we often say, oh, these goods were dumped. What does it mean? What does it cover? And is it permitted, you think, under the World Trade Organization agreement and under general trade agreement? What is dumping? I don't, yeah, excellent. Because again, we have sometimes some sort of misconceptions on what's dumping.
Dumping in a nutshell is selling goods below the fair market price.
That's excellent. We have already a quite technical description. This is selling a good below market price, and this good, or maybe service, but very often it's more products, goods. They're national goods, exported or imported goods. Yeah, probably in our context. All right, let's look at that into the details, because again, this is a tricky one and quite complex. So dumping. We have a special agreement in the WTO agreement on dumping. Dumping is essentially a price discrimination in international markets, a price discrimination. Anti-dumping is a specific action against dumping, which may result in imposition of higher duties, price undertaking, or provisional measures in the form of cash, security, or bond. Anti-dumping is widely recognized and applies as one of the key components of trade remedy instruments. The other two include countervailing duty measures and safeguard actions. Certain domestic anti-dumping laws implemented in the early part of the 20th century also address predatory pricing in addition to international price discrimination. Predatory pricing is no longer addressed in anti-dumping law, although certain home market below cost sales are disregarded from anti-dumping determination. So you understood as well that it's going to be technical. And one of the problem with dumping is that you have to prove it. You have, as the claimant, so to speak, you say, oh, I'm a victim of dumping. You have to prove that you are a victim of dumping to impose anti-dumping measures. You see? All right. Let's go on as much as I can. I'm stuck apparently. Sorry, could you move to the next slide for me? All right, suspend. All right, no, it's the next. No, that's me. And that's nothing. All right, let's go. And I'm sorry, I can't click on the page. Okay. So before you, here we go. Maybe it works. So the anti-dumping agreement, I was telling you that there is a special agreement within the WTO agreement framework. Anti-dumping agreement seeks to protect the domestic industry in the importing country against injurious dumping. So exactly what I told you. Imagine that certain goods are, so to speak, dumped. I don't really use this term, a sort of layman term. But imagine that certain goods are dumped into this country, Uganda. You can protect yourself, but you will have to prove that there was indeed an injury in your market, to your market. The extent of anti-dumping protection is limited to the price difference between an exporter's home market and export sales to the country applying the anti-dumping remedy. In addition to dumping, injury and causation are also required to be established. This is to say, and probably our colleague from the Trade Ministry is going to tell us whether you have, here a sort of task force on dumping, but this is to say that, again, you have to have a number of technical people investigating and proving dumping. You have been injured by these particular products in that there is a price difference between the exporter's home market. Let's take the example of China, because I suppose that a number of investigations are against China for the reason that it's a massive trader, and export sell to the country applying the anti-dumping remedies. So let's take the example of Uganda, for instance. The anti-dumping agreement provides detailed substantive rules for the conduct and implementation of anti-dumping proceedings and reviews. The extent of anti-dumping duty cannot in any case exceed the margin of dumping. Certain countries implement the lesser duty rule where the duties are sufficient to offset the injury. So I think you understood the principle. You have been harmed. There is an injury to your market, a price difference which is such that your market is injured. You investigate, and then you can impose duties, but not crazy duties, corresponding to this price difference and remediating to some extent the problem. One of the controversial topics in anti-dumping is the practice of zeroing, another super complex technical issue in trade. As a practice, zeroing is prohibited in most forms of anti-dumping proceedings, including original proceedings, periodic interim reviews, and expiry reviews. I don't really want to get into the details of zeroing here today, but let's say that it's a practice of anti-dumping which exceeds what's permitted in international trade. Anti-dumping provisions are also negotiated as a part of free trade agreements, and you do have new regional free trade agreements indeed. Let's move to another quite contentious discussion: subsidies, countervailing measures, and safeguards. So again, you remember we talked about subsidies in agriculture. There's a special section of subsidies or for subsidies in the agriculture agreement, but there's another agreement on subsidies, countervailing measures, and safeguards. So what sort of industry can you subsidize, and for what reason, you think? This is a practice extremely common. It happens everywhere in the world. Why would you subsidize a given industry? And which one? Surely in Uganda, you subsidize a number of things. Go ahead.
It depends on the nature of the industry and significance of the industry to the country. For example, if it's agriculture or it's your perhaps your number one export or your signature export out there in the market, you subsidize it perhaps to give it an edge or a competitive edge in the market.
Exactly.
So that it can compete globally.
Exactly. So question of competitiveness, question of growing your domestic industry in a given sector, and again, agriculture is slightly separate, but somehow the reasoning is similar. To give you an example, because there's a massive case at the WTO, there was a massive case, Airbus and Boeing. We're talking about giants, right? Highly subsidized. Boeing is highly subsidized. Airbus is highly subsidized. They brought the case to the WTO. Lengthy, technical, and maybe not so WTO relevant, because you can say that's the right of countries to regulate. That's their sovereignty to some extent to subsidize this type of, technical, pioneering, specific, strategic industries. So subsidies are indeed a big problem in trade and have generated a massive amount of disputes. So multilateral disciplines on subsidies are aimed at eliminating or reducing trade distorting subsidies. So it's not that subsidies are prohibited, they are not, but what is prohibited is sort of the distortion on trade, which is a problem. Not all government support or financially contribute can amount to a subsidy. The SCM agreement requires certain fundamental elements to actually determine what's a subsidy. It deals with a number of categories. Indeed, to be met, these elements have to be met, and they are. It has to be a financial contribution or benefit. In addition, for a subsidy to be actionable, it should be specific. So you can imagine that in dispute settlement, you have all sorts of discussion on whether it's a financial contribution, a benefit, and if it's specific or not. So tell me something. Imagine if you have a tax rebate, is it a subsidy? I've heard yes, I've heard no. Maybe. So it has to be, again, investigated, but it could well be a benefit, right? It might not be a financial contribution as such, but surely a benefit. Okay. The SCM agreement addresses subsidies provided by a government or any public body within the territory of a member. Here again, why is it so important? A government, everybody got it, or any public body. Super interesting. And you have plenty of China-related cases addressing the problem of what's a public body. What do I have in mind here, you think? What can it be, a public body, if it's not the government as such? What about state-controlled or state-owned companies? Somehow they are public bodies, right? This is what was at the center of the China-related cases. So is it possible for a state-owned, state-controlled enterprise to give a contribution to another sector of the economy, so much so that it constitutes a subsidy? Yeah. But again, it has to be proven. Okay. So you see what I mean here. Not all subsidies in the economic sense are captured by the agreement. Subsidies to domestic product are permissible, but actionable if they cause adverse effects. Again, it's not that subsidies are prohibited, but they sometimes are too much. They cause an effect. In addition, such subsidies should be given in conformity with the Article 3 of the GATT. So the agreement deals with 3 categories of subsidy: prohibited, actionable, and non-actionable. This last category expired in 1999. Also, you have the problem of export subsidies, export and import substitution subsidies, where they are per se specific and are prohibited. These subsidies can be directly challenged before the WTO dispute settlement body. And you do have a number of exceptions, which are also listed in this agreement. Again, as you understood, for dumping, it's the same principle. You have to have an investigation, show that there is a subsidy, show that there is an injury, and show that there is a link between the subsidy and the injury. Quite complex. Then you can have safeguard measures available to restrict imports from other WTO members, provided that the surge in import can cause or threaten to cause injury to the domestic industry. Safeguard measures are temporary and meant to facilitate structural adjustment within the industry. Right. So that's then the Article 1 here of the SMN agreement with the definition of the subsidy. I'm not reading it now. I'll give you time to read it at home, but this is basically capturing what I just told you. Here we go. Then let's move to another important topic. I know we're covering a lot, but as you understood, these are foundations to give you some sort of general ideas of what's trade and investment about. So let's talk briefly about the TRIPS, the trade-related aspects of international property. TRIPS is the first major international treaty on trade, providing standard protection for patents. And the purpose was to provide effective and adequate protection of intellectual property rights as part of a multilateral trade agreements. And they embody the key principle, as I told you before, of MFN and national treatment. TRIPS provide minimal level of substantive protection for copyright, trademark, geographical indication, industrial design, patent, layout, integrated circuits, and so on and so forth. And they also incorporate the Paris Convention 67 for the protection of industrial property and the Berne Convention 71 for the protection of literary and artistic works. So quite large. Again, a quite contentious topic, in particular for developing countries and indigenous knowledge and medicine. You may remember during COVID, we had a TRIPS-related discussion on vaccine, whether they should be covered by the WTO TRIPS agreement or whether we should have a waiver so that this vaccine could be better distributed in the world. India, South Africa had proposed a waiver to the TRIPS agreement so that indeed vaccine could be more circulated without too much intellectual property discussions, but it didn't go through for the reason you can easily imagine. TRIPS provide the intellectual property holder the exclusive right to authorize or control his or her work. TRIPS provide a 20-year period for patent protection and copyright protection of life of the author plus 50 years. Again, extremely complicated and contentious agreement for the reason we've just alluded to, because it might well be that TRIPS sometimes reduce trade or harm certain countries' trade or certain products. Now, briefly as well, and we're almost done with the WTO, and then you'll have a bit of investment law. Trade in services, another fascinating area of the WTO. Integral part of the agreement. You have a specific agreement on trade in services. The principles are relatively simple. These principles of the GATS, the General Agreement on Trade in Services. You recognize cross-border services. This is also something you see in the African agreement. And it's based on the idea of what we call schedule or disciplines, schedule of concessions. A member service schedule comprises a sector-specific commitment on market access, national treatment, and indeed each mode of supply and the additional commitments. So we took the example before of the legal profession, education, medical services, transport services, and so on and so forth. So it's up to a country to decide whether or not they want to open up this particular sector of their industry. Now, let's move quickly to trade exception. What I find fascinating in the WTO sort of agreement is that not only you have plenty of agreements, but you also have exceptions. Exception, you remember, we just alluded to that in services, because you don't necessarily have to open up everything. It's your choice. Exception to the national treatment in this regard, but also general exception, which are listed in the quite famous Article 20 of the GATS. And they cover, for example, national security exceptions if you consider that your national security could be threatened if you allow certain importation, for instance. This article is not very difficult, but not very easy to implement. You have a number of disputes which have, addressed this article, but generally it's not been very easy for countries, and they have never been very successful in trying to implement this agreement, and precisely this Article 20 on exception. Now let's move quickly to dispute settlement. So how does it work, actually? I'm going to ask you a few questions. How does it work, dispute settlement within the WTO? And you see it's exactly the same, really, in regional agreements and in the future African agreement in the future. I mean, in the upcoming African agreement, it's quite similar. How does it work? Maybe.
How it works is, for example, dumping. If you notice that a certain good is being dumped into your market, Uganda, for example, you'll go to your government, and your government will bring a claim against the country that is dumping. And every trading, the WTO has a dispute settlement system. So that's where you take your claim. And under the African Continental Free Trade Agreement, there's a different dispute system that has been provided for. So, and I assume disputes within the intra-African trade will be dealt with within that system.
Yes, sure. So you said many very important things. There's something a bit paradoxical here, because disputes, as you all understood, within the WTO, is going to be dispute between two countries, right? Or a group and another country. For example, the European Union comes as a group against, let's say, America, or the US, or I don't know, India, right? But it is a bit paradoxical, because who is trading? Not necessarily countries, right? The private sector. So you have the company B, which is trading mangoes or auto parts or Boeing, Airbus, or maybe, what can I say, trucks or fibers or steel. Well, okay, you name it. So these private companies, they're going to come to their government and say, well, in our sector, we have been, we think, victim of dumping, illegal subsidization, breaches to the MFN, breaches to the national treatment. And so they are going to lobby their government so that their government brings a claim against another government. You see? So that's the sort of paradox of the WTO, because we're talking about private actors doing the trade, but public actors, the state, acting on behalf somehow of their industry. Okay. And it's very different in investment because, as you will see, and you probably know already, you have the private actor in investment. But let's go into the details of how it works very briefly. So the dispute settlement mechanism of the WTO is rooted into the Article 22 and 33 of the GATT 47. There's a special agreement as well, which is called the Dispute Settlement Understanding, improved upon the dispute mechanism of the GATT 47. And it was very key, and it's certainly a very important success of the WTO. You know that the WTO negotiations are sort in a standstill at the moment, but however, dispute settlement is still relatively successful, although the mechanism is a bit blocked. So the DSU, this agreement provides strict timelines for the dispute settlement mechanism and consists of 4 key steps. Consultations. Remember, we're talking about a state and another state. So it's key that you first negotiate, you consult. It's initial, it's non-judicial, and it's a diplomatic method through which members can resolve a dispute. So you're going to meet with South Africa and say, well, I'm so sorry, but this doesn't work. Can we come to maybe some sort of mutual agreement? Then you have another stage, panel. So this begins the sort of adjudicative process and includes written submission, arguments, and evidence before the panelists. So this has happened. I'm demonstrating this and that. Please solve this problem. Somehow it's close to arbitration. You have panelists, it's not a court as such, it's more a panel of experts, and they're going to look into the problem and tell you whether you're right or wrong, produce a report, and suggest some solutions. And then if it doesn't work, you may appeal this panel report and move to the appellate stage at the appellate body of the WTO. Which is interesting is that the panels are not permanent. They are ad hoc, made of experts for this and that question. But the appellate body is permanent and made of a number of members. They're not judges, but they are members, again, relatively close intellectually to arbitration, but permanent within the WTO. As you may know, for the past maybe 5 years now, the appellate body is quite blocked because the United States has refused to appoint new members. So it has de facto blocked the functioning of the system, although countries have tried to work around the system and still work at the panel level. And some of them, including the European Union, have tried to create their own system, parallel system. So it's going to be interesting to see what the new African Continental Free Trade Agreement does in terms of dispute, because it might be that you're going to have more disputes within Africa, which go direct to the African Union, or African agreement rather. Since the establishment of the WTO dispute settlement system, the WTO has received almost 600 dispute consultation requests, making it one of the most active international law tribunals, probably the most active really. It's a massive amount of disputes. Nothing compared to maybe a national court, but it is massive. It's probably 10 times more than the International Court of Justice, really. If you have in mind the number of disputes at the International Court of Justice is almost nothing compared to that 600. The reason is that trade is very active. We trade, so we have potential disputes all the time. Recently, we had this conversation, and I remember I said having disputes is not a problem. It just shows the sort of dynamism of your economy as well. Since China has exceeded the WTO about 20 years ago now, it has had a large number of disputes, which makes sense because it's one of the largest traders. So it makes sense that people are going to tell you, no, I'm sorry, this is dumping. I'm sorry, this is illegal subsidization, and so on and so forth. And as I just said, the WTO is facing a major crisis at the moment because of the blockage of the appellate body. Now, do you have any questions before we move to investment law? Yeah?
Thank you. My question is in relation to dumping.
Yes.
So from your explanation, it's about price discrimination.
Yes.
And I'm thinking, what if my method of production substantially makes my cost really low, that I can afford to put my goods out into your markets at a price that's considerably low? Would that still amount to dumping, or it's dumping just because?
It's an excellent question. Excellent question. I don't know if you heard everybody, your colleague was saying, imagine my method of production for some reason allows me to produce at a very cheap cost, right? Very cheap price. So, and then I export my goods to your country. Is it dumping? You remember the definition. There is a price difference between the domestic market where these goods are produced and the market where they are exported. So it's not so much the price difference between the cost of production and what, the price in the export market, but rather the domestic market and the export market. So let's imagine you produce something and you're going to price it at $1 in country A, and then you export it and you price it at 33p in the export market. You see, that's a problem. Okay, great. You're welcome.
My question is about, and a lot has been written about this, but I'm always interested in listening to experts' opinions on it. It's written that, and it is true that Africans have not properly or adequately used the dispute settlement mechanism under the World Trade Organization. What's your take on that? What causes that? What has caused that? And also, how many disputes are there now? Involving Africa?
Okay, that's very interesting.
Okay, then a quick one. What's the take on this new mechanism that was brought? I think it's called the multi-party interim appeal mechanism or something like that.
Yeah.
Is it going to work? Is it something that you think will be efficient as far as especially resolving the impasse concerning the appellate body?
Excellent question. So you heard everybody. First question, how come is Africa not very much represented within the WTO dispute settlement system? And second, is the new mechanism, which is a bit interim, put in place until we reform the WTO, is going to work? So why is Africa not very represented? You have different explanations. So some say, oh, we don't have the technical expertise and we don't know how to place a dispute, so we don't dare to. Maybe, or maybe simply because until now and until recently, the volume of trade from African countries is not massive. So why would you have many Africa-related disputes if you don't have that much trade, right? As I said before, if you look at the list of disputes on the WTO website, you'll see it's fascinating because you see the countries topping the list, the US, Europe, and China. They have disputes all the time. Why? Because they trade a lot. They trade a lot, so it creates problems, of course. You have very few disputes within the developing world because, again, they're not very represented in the trade scene, right? So that's, to me, it's the main reason. Then you may say, again, we don't have the technical expertise. It's so costly in terms of human work and also financial costs. But I really don't think it's necessarily the reason. You've had a lot of training programs to train diplomats and, to access the system. We'll see, but it seems to me that it also relates to the volume of trade. And I understand that obviously it's so technical that it might be impeding the process. Yes, go ahead. Mm-hmm. Oh, yeah. All right.
Yes, in this particular space. So I think part of the problem is capacity building.
Sure.
Yes, as we can see technically, there are really very few people here who understand aspects of international trade.
Of course.
Investment law.
Of course, that's for sure. That's for sure a big problem. But whether it's the only explanation, I'm not sure. But of course, and you had a very large number of training programs, as I said, from the WTO, from side organization, training, building capacity in the developing countries, and in particular in African countries. That might not be enough. I think you have to take all these two criteria, the lack of capacity for sure, but also the fact that you might not have that many disputes. What's going to be really interesting, as I said, is to see what's going to happen within Africa itself now that you have an African agreement, you know, and a dispute mechanism which is specially designed for the continent. And to respond to your last question, whether the sort of temporary mechanism is going to be efficient, it's temporary. So honestly, I'm not so sure. And I have no idea how the blockage, the problem of the dispute settlement body is going to be resolved, because it's a diplomatic problem. As you understood, somehow it's also a diplomatic way of settling disputes. And as long as the United States is blocking the dispute settlement mechanism, nothing much is going to happen. And that's precisely one of the reasons why a number of regions of the world have also decided to reinforce their regional mechanism to sort of work around the blockage of the WTO, right? Good, everybody. We don't have much time, so I'd like to move to international investment law to give you some foundations as well. And then we'll have a panel discussion, and then we'll try to work together on a few exercises. International investment law is part of international economic law, as you understood, and generally what we call trade. Very often we call trade and we cover trade and investment together, but it's another sort of discipline and not so far in a way from trade. Today you have around 3,000 international investment agreements, including 2,300 something bilateral investment treaties. It changes all the time, but these are the large figures, so to speak. And more than 300 treaties with investment provisions. So you'll see that the African agreement is one of them. You have a trade and investment treaty, interestingly. It's a rather old discipline of international economic law, but it's interesting that it has been under the spotlight for maybe 10, 20 years because of a number of big disputes, including a number of states and recently European states as well. It's very diverse in terms of sources, and also diverse because you have a number of very inconsistent decisions from investment tribunal. It has only recently captured the attention, as I was telling you. And the interest is also related to the growth of FDI, foreign direct investment, in the past 2 decades. So now everybody is investing, you know, it's not north-south or anything like that. You have investments within Africa, from Africa to Asia, from Asia to Africa. So particularly interesting and complex. The history of international investment law also reveals a pendulum swing between liberalization, promotion, and protection of FDI, and protection of the state's interests. So on the contrary to trade, in this particular domain, we don't only have the state, but we have the state and investors. So that's the way bilateral treaties are constructed. So you have indeed a lot of sort of conceptual approaches to foreign direct investment and whether they are important or not. There are at least 4 categories of international investment actors: the state, the foreign investors, in the form of private or public entities. Very interesting to see again the role of state-owned or state-controlled companies, international organization, and civil society. And today's international law scholarship supports the need for looking at this particular area. The law of international investment, really interesting as well. It's bilateral in treaty, but not only that. The idea is to help attract, protect, and promote foreign investment and provide a certain degree of stability and predictability for the investors as well as the state. It also serves to resolve international investment disputes. And in fact, if you look at it closer, you see that there are somehow 3 laws of international investment: national, contractual, and international. You know very well that you have, I suppose, in Uganda as elsewhere, a national investment law regime. So to enter in Uganda, you have to abide by a number of conditions, and that's your national investment law. You also have contractual investment law, a contract between a given firm, let's imagine Airbus, and a state. And you also have international investment law, what we're dealing with today in the form of bilateral or multilateral investment treaty. It's important to have that in mind because it's more complex than what it looks. When we talk about investment law, it's not only bilateral investment treaties, but your national regime of investment, whether you accept the entry or not of given investment, the contract you might sign between the given state A and the company B, and also international investment law. They are interrelated, but our approach is state-centric and based on international agreements. There is indeed a very great variety of national investment regime, and it has created somehow some confusions between national investment law, contracts, and international law. A number of controversial provisions are found in international investment law as well, such as stabilization or umbrella clauses. Stabilization clauses, you might have heard about that, quite technical as well. You stabilize the contract for a given period of time. And this is controversial because you, as a state, might want to change your policies for public reasons, but you might not be able to, or if you do, you might breach your contract. And umbrella clauses are clauses, linking a contract and a bilateral investment treaty. So again, here the devil's into the detail. When you talk about investments, you don't only have to look at international investment law, but also at national law and contractual law. All right, let's move on. They provide a vast network of binding obligation. They're very often specialized regime or analyzed as special regime, and however, they are part of general international law. As I said before, you have more than 3,000 of these type of agreements. They all rely on public international law and so the Vienna Convention on the Law of Treaties. And what has been questioned a lot is we can't use the term case law because there's no such thing, but are the decisions of the various arbitration bodies or arbitral tribunal. The same principle as in trade, interpreted slightly differently though: national treatment, most favored nation treatment, fair and equitable treatment, full protection and security are of great importance. And these principles you'll see in the treaties. When we do our exercise together, I'll ask you to identify this principle in the African Agreement. And how do you settle disputes? Very differently actually than in trade. As you understood, you have a dispute between a state and an investor. And this is really strange if you think about it, because it's not private dispute, it's not public dispute, it's a mix. And this is a system which has been created within the bilateral investment treaties accepted by states. And it's also a system which is quite unbalanced because only the investor can sue the state and not the opposite. So really, if you have that in mind, these investment treaties were created to protect the rights of investors, as simple as that, in the 60s and 70s, investors investing in particular in the developing world. But now, you know, the wheel somehow has turned, and you see that the same countries which had created these bilateral treaties, mostly European and American countries, are now very much sued by investors and are starting to question the system. In dispute settlement, the state responsibility is questioned. So the investor is going to say, you have breached this bilateral investment treaty in doing this and that, in not respecting MFN or the principle of, I don't know, maybe security. And so your responsibility as the state is engaged. Where do you solve this dispute? You have mostly a system which is the most active is still the World Bank-based International Center for the Settlement of Investment Dispute, the ICSID you've probably heard about. And you can also solve a number of investment disputes in sort of ad hoc system like the Chamber of Commerce or the Stockholm arbitration, or, you know, Singapore or Dubai, and you name them. And interestingly, I think there are some efforts regionally to create relatively similar bodies, and that's going to be interesting to see whether you can have a regional investment dispute settlement mechanism. Right, here we are. We can take a break, I think, now, move maybe to the panel and later do our exercise. unless you have a few questions, we have a few questions. We went quite fast. And as you understood, there is so much to cover, but this gives you a general idea. Any question?
Okay, if there are no questions, we can go straight to the panel because we are going to have a session for Q&A. So in case of any questions, they can be taken there. Let's just give an applause to Leila. Leila, thank you so much for that elaborate presentation. And once again, this presentation is going to be shared on email. If you registered, I'm sure that ULS has your email address, and so we shall share.
Absolutely. We share the presentation and I'll share as many resources as possible. Same thing for our online colleagues. And if you have questions, write down your questions. If you reflect upon a few things that we've just discussed during our panel moment as well. Thanks a lot, everybody.
Maybe in a special way, we want to appreciate Leila. She's shared her books, she's authored, and the Cambridge University Press did email them. And once our law firm receives them, we shall share them with the Uganda Law Society so that the resources are available to everybody that needs to access them. Thank you, Leila, for that wonderful contribution. Welcome. All right, and we would like, Leila, you kindly take a seat at the front. You'll be part of the panel. And ladies and gentlemen, today we are privileged to have a mixed panel with experts from the legal practice as well as the government side. And we have Counsel David Mutegeki from the Ministry of Trade, Industry and Cooperative. He holds a Master's of Law and Finance from the University of Leeds. Currently, he works with the Ministry of Trade. He's also undertaking research in another LLM at Makerere University. He's a scholar for international trade law at the International Trade Center. And today he's here with us to give us a perspective from the government. Ladies and gentlemen, let us welcome David. We also joined by Ivan Ojako. He's a private practitioner, a commercial lawyer with specialty in trade, technology, and media, and several other disciplines. But he is also a practitioner in international trade privately. He advises clients on a range of issues. And ladies and gentlemen, let's welcome Ivan as well. And to join the panel is Mabel Kisaka Mutunji, a managing partner at Mesa Advocates, a firm that is specializing in international trade law in Uganda. She holds an LLM from the University of Georgetown. She has practiced with several export businesses in the country, and she comes with a wealth of knowledge to this panel. Thank you. Let us welcome Mabel as well. And this session really is to elaborate on how a Ugandan lawyer like me can be able to participate in this international trade and investment law space. I'm going to join them at the table so that we can have a closer discussion.
Thank you very much. Well, are you sharing once you get that, right?
Yes.
Excellent.
Maybe we shall start with David to really give us a snapshot of the AFCFTA. What's the current status of that as a Ugandan lawyer? What information would you give us regarding that?
Good afternoon, I believe. So let me take you back to the history of how we arrived at the African Continental Free Trade Area. We started It started on the 18th ordinary session of the Assembly of the African Union in Addis Ababa, Ethiopia, on the 23rd to the 30th of January 2012, where African leaders then recognized the importance of promoting intra-African trade as a fundamental factor for sustainable economic development. So at the assembly of these leaders, a thought of having trade within one Africa was envisioned. So fast forward, March 21st, 2018, after 10 negotiating rounds, 44 out of 55 African Union member states, Uganda being a member of the African Union, signed the agreement establishing the African Continental Free Trade Area. So this vision started in 2012. It was concluded on the March 21st, 2018. So this agreement was tabled before the cabinet before March 21st, 2018, and cabinet agreed that Uganda signs and ratifies the African Continental Free Trade Area. So Uganda became one of the 44 out of the 55 African states to sign and ratify the African Continental Free Trade Area. So cabinet in that same sitting created a subcommittee, a cabinet subcommittee, whereby Minister of Trade was appointed to chair this cabinet subcommittee. It also consisted of Minister of Finance, Planning and Economic Development, Minister of Foreign Affairs, Minister of Agriculture, Minister of Tourism, Ministry of Energy and Mineral Development, Minister of Works, Minister of East African Affairs, and the Office of the President to coordinate and see how best the African Continental Free Trade Area could be, 1, envisioned, 2, implemented, and 3, becomes part of our everyday trade and becomes part of the Vision 2040 to drive the national agenda. So
maybe just to interrupt you, yes, this agreement is in place, but as practitioners here, some people have actually not even heard about the agreement. What steps is the government taking to ensure that this agreement is out there, to ensure that lawyers are prepared or businesses are prepared to actually take part in this free trade? And maybe just, you've said that different ministries were brought on table to spearhead. What is the place for a private practitioner? How do we as lawyers come in? You're from government. How do us benefit?
That's a good one. In October 2022, October last year, the Ministry of Trade fronted, because Uganda is negotiating through the East African Community. We're negotiating as a bloc. We're not negotiating as a state. However, we fronted to the East African Community something we call the East African Schedule of Specific Commitment, and we concluded it, and we forwarded it to the African Union on the 9th Council of African Ministers of Trade. The core, I believe, the legal department of Ministry of Trade forwarded legal services as the top core of professional services for our schedule of specific commitments. We forwarded legal services, become the forefront of trading services that shall lead Uganda's agenda under the African Continental Free Trade Area. So, whereas we are still figuring out a way on how to deal with East African community in legal services, we've also made it part of our commitment as government to have legal services as the core of our negotiation for the African Continental Free Trade Area. That notwithstanding, Minister of Trade established a committee, being the chair, established a committee to come up with a countrywide task force to spread the gospel about the African Continental Free Trade Area. However, we so far have consulted two stakeholders, the business community and MSMEs. This committee is going to also consult Uganda Law Society and the legal field in general. Then we come up with a countrywide consultation so that we spread the gospel of the African Continental Free Trade Area, because this is the future of us, this is the future of Africa, this is the future of Uganda.
Thank you, David. Maybe to go to Mabel, who's practicing in this space. Does this African Continental Free Trade Agreement, does it provide for trade and services? And if it does, what are some of these services that are provided for?
Thank you very much, Agatha. An important feature of the African Continental Free Trade Agreement was the inclusion of the Protocol of Trade in Services and the decision to conduct concurrent negotiations on both trade in goods and trade in services. The prioritization of services with the African Free Continental Trade Agreement is a shift from what we are used to. For example, when negotiations were happening for the East African community, trade in services was not something that was prioritized. So it wasn't in the first phase. But with the African Continental Free Trade Agreement, trade in services was in the first phase. And 5 priority service sectors were agreed for negotiation. And these include business services, communication services, financial services, tourism and travel, and transport. And as lawyers, we fall under the business services. So Professor Leila mentioned earlier that it is up to the country to decide on what to open up and how to open up when it comes to trade in services. So trade in services does not work the way trade in goods works. It works differently. I'll give you an example with the East African community, for example. We have Rwanda that opened up their legal services, and Uganda and other East African countries have not opened up their legal services to other East African countries. So that same applies for the African Continental Free Trade Agreement. So currently, under the African Continental Free Trade Agreement, South Africa, Seychelles, and Comoros have in their offer permitted for trade in legal services for only foreign and international law, but they have not allowed for domestic law. So a Ugandan can set up shop in South Africa, for example, and practice international and foreign law, but will not be allowed to practice domestic law. And how does the African Continental Free Trade Agreement help us as lawyers? If a practitioner wants to open up shop in these countries to practice foreign and international law, all you need is approved credentials and approvals from your regional law society or the appropriate legal body. So under the African Free Continental Agreement, you don't have to go through the immigration processes of work permits and the like. And without the agreement, you'll have to go through that tedious process so that you're able to practice in those jurisdictions. Countries can also limit the number of days for foreign professionals under the African Continental Trading Services. For example, Seychelles has opened up legal services for foreign and international law, as I earlier said, but it has limited the number of days to 128 days as the maximum number of days a legal practitioner can practice in Seychelles. And I'm happy to hear from the representative from the Ministry of Trade that Uganda is opening up, has made concessions to that effect. And I hope we open up for international trade practitioners, foreign international trade practitioners to come in, or for us to prepare to practice in other regions. And for us as lawyers, how can we build capacity so that we are able to compete fairly? Because as we've heard, Uganda is in the process of opening up. So we need to create partnerships, number one, with other regional law firms. We need to embrace arbitration. Like Leila said, arbitration is going to be key to settle disputes. And we need to build capacity in the area of international law, international trade, and the general public international law.
Thank you, Mabel, for that elaborate answer. Let me just go over to Ivan next to me. Ivan, we've heard from Mabel how there's opening of trade and services, but the audience we have is for lawyers. What is the role of a lawyer in an international trade transaction? How do we come in?
Thank you very much, Agatha, for your question. Importantly for me, the role of a lawyer, one, is to have information. Like Mabel was mentioned, like Professor mentioned earlier, there is a lack of information among lawyers. One, information comes with education. Yes, there's a bit of teaching. I'm a teacher at a university. I teach at the International University of East Africa, where, by the way, we are pioneering the first of its kind LLM international trade law coming out before the end of this year. So watch out for that. So there's a bit of teaching of it, but not that expansive teaching, as far as especially international economic law and things like WTO are concerned. There's more of teaching of Incoterms and that is trade law still, but it may not cover the whole breadth of international economic law as it should be covered. So information, importantly, Mr. David Mutegeti has mentioned that Uganda has submitted a constitution as far as legal services is concerned. But how do lawyers get that information? If you go to the Ministry of Trade website, for example, you'll not find anything like that. There's a repository of international instruments, international trade instruments that Uganda has entered into. Even the AFCFTA arguments, almost every day I receive a WhatsApp from a lawyer asking me, Ivan, send me the AFCFTA argument, because they cannot find them online from anywhere. You have to go to like TRALAC. TRALAC is a trade law center to get that information. So information. With information comes empowerment as far as negotiating on behalf of government is concerned. Many times, government doesn't even carry lawyers for these international trade negotiations. The stories always come out that whenever our representatives go to Geneva, they just go to Galavant and take coffee and take pictures and just enjoy themselves. And interestingly, I've listened to some interesting practitioners in the region who have told me, the economists, trade economists, they say, we barely see lawyers in these negotiations, in these discussions. Yet you and I know just about maybe about 20 lawyers, for example, have gone to South Africa and done the LLM international trade law and investment, either from University of Western Cape or University of Pretoria. But we are missing in the space. That empowers us to negotiate better on behalf of our governments and have better trade instruments. With information comes the ability to resolve disputes in international trade. Unfortunately, again, I'm a bit of a skeptic as far as the AFCFTA is concerned for us more or less copying and pasting the WTO dispute settlement mechanism. The FCA sort of resolves that impasse by saying that regional economic communities are building blocks towards the AFCFTA. As we know, when your client has a dispute, again, the reluctance of governments to take on each other, because it's going to be a state dispute settlement mechanism, which will be difficult. You know, governments, maybe your government to go and represent you over Kenya blocking, this may be a problem from experience. So, that allows a private party to take on a government. Of course, there's a few problems with the 60-day limitation period and what have you. In fact, you properly represent your clients effectively within the right dispute settlement mechanism or forum whenever a trade dispute arises. With that, you'll be able to advise your clients as far as investment decisions is concerned. There is an investment protocol that is coming that I've seen the draft, but state official. I think the Assembly of Heads of State is supposed to sit. Has it this last week or supposed to sit and approve it? The protocol on competition and intellectual property. Then we can see what is there properly. But you need to advise your client whether to invest properly and how to invest. You need to advise them on regulatory forms concerning rules of origin, etc. So that again comes with information and being skilled in the area. With that comes again ability to lobby and good use of trade and tables and like we want lawyers, we want in as far as these things are concerned. From experience, again, the guys at Ministry of Trade, I'm sorry, Mr. David Mutegeki, I've dealt with a couple of your seniors, but they really, I don't know, it's an in-house thing. I think they don't really want, I don't know, maybe they want to share the bread, I don't know. So yeah, lawyers many times are left out of these things. So you can lobby your government to put in place. For example, there's we don't know if there's investment law reform concerning ICDS, for example, like Professor mentioned earlier, that is going on all over the world. But we still have very many bilateral investment treaties that are existent right now of Uganda and other countries, especially countries from the Western world, that are honestly really unfavorable as far as we're concerned. So we don't have proper investment law reform that is going on. Only a lawyer who's skilled, who has information, can be able to push for that, can be able to advocate for that. Institutional infrastructure, so many opportunities are opening up. Besides the four main bodies, the heads of Assembly of Heads of State, Council of Ministers, the third one is called the Committee of Senior Officials and the Secretariat. There are also small committees that are being created under the different protocols. For example, Committee on Trade and Services, Committee on Trade in Goods, Committee on Trade Facilitation, Committee on Rules of Origin, Committee on Technical. So all of that are opportunities for lawyers to position themselves, as they say in our colloquial Luganda, kwetega, and you properly get in there and enjoy the opportunities beyond your Chibanja practice. But importantly, let us scale up. The universities that are, I mentioned my university, we're setting up this program very soon, but there's Stralak, there's Trapka, there's the great universities in South Africa that have done this for ages, that can properly scale up. Of course, there are many international universities that are doing this where professor teaches, for example. Please, let's get skilled, let's get information, and we properly become experts in this area so that we can properly enjoy the opportunities that come in international trade, from trade remedies to trade finance to many things. So yeah, I hope I've answered your question, Agatha.
Yes, you've done justice to that question. Maybe wants to add something to that.
As a practicing lawyer in the area of international trade, I have also interfaced with the Ministry of Trade. I've had a meeting actually with the minister, and I think one of the hindrances was the fact that lawyers are not organized in this area of the law, and that is why we pushed for Uganda Law Society to create a cluster, because they assured us that they intend to get representatives to represent them in WTO negotiations and other negotiations. So I'm very grateful to the Uganda Law Society for allowing to formulate this cluster. And for all of you who are passionate about international trade, I believe we're going to move forward from here. And I think my colleague can add something, since I've had conversations with him at the ministry.
Thank you, Mebo. We've been partially rightly accused of not sharing information. However, we've have not been approached personally, though that is not his problem. We've not posted this information on the website, which is true. That's why we are admitting that failure. However, I applaud Uganda Law Society for creating this cluster. Now we have a framework of interacting with lawyers. These trade negotiations, most of us may not be that much skilled in government in trade negotiations. However, Uganda Law Society, as a large society, is well capacitated with very senior lawyers, well seasoned in trade negotiations. And I believe as a country, if part of you people have had the benefit of being in Geneva, you've seen how the Americans negotiate. You find that the Americans carry 100 lawyers for trade negotiation, and Uganda only has maybe David and the minister negotiating against 100 lawyers. But we have well-seasoned negotiators under Uganda Law Society. Now, we've created a cluster of international law. So we've equipped the country. You don't know the advantage you've created by creating such a cluster. You've advantaged Uganda beyond measure, actually, because now we've created a panel that can be consulted at any given time, and partly members of such a cluster can be utilized by the government of Uganda in handling trade negotiations, sometimes even on behalf of the ministry, especially where their expertise is highly required.
Thank you very much, David, for that confirmation. And we are going to take the Ministry of Trade up for this opportunity. The cluster has been made, and we are going to ensure that Uganda Law Society sends out that email to call any lawyer that wants to be part of the cluster and committee to join forces so that we can work together with the ministry. Ivan wanted to.
Yeah, I just want to quickly also address a point that was raised by David. The point of opening up of legal services. The schedule of commitments is a bit vague. When we say, especially because it says the EAC is negotiating as a block, Uganda has offered to open up legal services. We're not sure if Tanzania, Kenya, and elsewhere. And that has been the same blockade as far as the MRA is concerned in East Africa. So how are we going to open up legal services under the AFCFTA if we cannot conclude our MRA? And how sure are we? Because when you say business services, like Bobo mentioned, that is a bit vague. It is not true that legal services are necessarily being looked at under those business services. It's also because of the variance as the legal systems across Africa. This is another problem, from Roman Dutch to civil law to common law. So that is going to be a major hindrance as far as the AFCFTA and opening up of legal services is concerned. So hopefully, I don't know how, but again, a united front like this one and our international trade law cluster perhaps can engage in serious lobbying and see how we can push that. But I think I'm not sure the commitment's been finished. It has concluded as far as I'm concerned. So I don't know, because it has not expressly mentioned legal services as being opened up, and that is a major hindrance as far as we're concerned.
Thank you, Ivan. Let's go to Leila. Leila, you have elaborately shared on some of the challenges being faced by the dispute mechanism. For example, the blockage by US. What lessons can you share with us on how we can deal with these challenges that affect these regional blocks, but also how can Africans or other trading blocks learn from Moldova?
Of course. I might respond to your question with a question to our colleague David, because I'm not. If you have a WTO dispute, would you go as a group? Would you go as East Africa or as Uganda?
Ordinarily, we are a signatory to WTO as a country, Uganda. However, in the instance of East African integration, we are adopting an East African. We are adopting going to trade negotiations, trade disputes, and all that as East Africa. We are no longer doing it as a country. We're now doing it more as a group, because it's better to negotiate, it's better to complain, it's better to win as a group than as a nation.
That's the reason I wanted to ask David, because first of all, he knows, I believe one step which could be really interesting in terms of capacity building for such complex disputes as WTO disputes. You understood from my short presentation, it's so technical. So super technical. And David gave the example of the US delegation coming with 100 negotiators. When they have a dispute, they have an army of like sort of internal ministry lawyers, but they also sometimes, engage lawyers from big firms, and they come extremely prepared. So I think you'll be stronger as a group to come as East Africa. You join forces. That's what the EU does. So one of the reasons EU is strong in dispute settlement is also because it comes as a group, right? To defend its own, interests. So that's one interesting strategy, I suppose, to harmonize the region strategies in terms of negotiation and dispute settlement for these extremely challenging disputes, which require a massive amount of technical expertise. This doesn't mean that you as firms, as lawyers in private practice shouldn't be equipped, because you're going to help a given government anywhere, or you're going to help the region. You're not limited necessarily to your state, right? To your country. Another thing I was looking at, because I was not very sure of the facts, Uganda seems to have 17 bilateral investment treaties, which is not very much, but it's already something. 17 bilateral investment treaties. You might be interested in having more, although now with the African agreement, somehow you have a network here in investment, and you have one case, a 2015 case. I think that would be interesting to look at it. It's actually Total against Uganda, which was settled, and the home state of the investor was the Netherlands. Again, very interesting, because Total is not a Dutch company, but you know how they play with the nationality and the corporate veil and all this stuff. that you know very well as a practicing lawyer. So look at that. I wonder whether you're going to have more investment dispute, but because Uganda is welcoming more international investment, question mark, but it's likely that in the future you might have a few more investment disputes, right? Okay.
Thank you, Leila. Let's just go back to David. In which areas really relating to international and regional trade can private lawyers work hand in hand with government lawyers? You have already said something in line with that, but what I would want to know, and I'm sure some people online and here would want to know, is there space for private lawyers in international trade negotiations and practice?
Absolutely. Absolutely.
Maybe you can elaborate
yes.
on those areas. How can we be part of that space?
Ordinarily, the Attorney General is supposed to represent Uganda in trade disputes, together with the Attorneys General of East Africa. However, sometimes you find that private lawyers are well equipped with better knowledge on a dispute than government lawyers. So ordinarily, we've been hiring international law firms out of the country to handle disputes on our behalf. However, and I would appreciate if ULS kept encouraging lawyers to further their knowledge in international law, majorly in settlement of trade disputes. One, settlement of trade disputes. Two, we are entering the whole new arena of mining and oil and gas. So, whereas we've educated lawyers in oil and gas law, very little or very few lawyers have been trained in the mining law. We focus so much on oil and gas, but you find that we have lots more minerals than oil and gas, and we've done little to train lawyers in that arena. So one is trade disputes, two is the mining law, and majorly to do with the negotiations on contracts, on disputes in case these contracts have been dirtied in any way. So we need more lawyers in that area of mining and trade disputes. Yes.
You answer that. I also want to ask you to shed more light on in assuming the African Continental Free Trade Agreement is already in place. What reasons do you think? What are the reasons why businesses might be interested in focusing on African markets, despite the challenges that have been faced in the past with the already existing regional blocks, the East African Community, the COMESA that we already had? What do you think would be the reason businesses would want to focus on our markets?
Thank you. Before I answer that, there is a role that I need to highlight, and that is legal advisory. For all businesses that are going to trade in the intra-African trade regime, as lawyers, we need to prepare them and advise them on the different tariffs and non-tariff measures, sanitary and phytosanitary standards and measures, and everything that Professor Leila shared earlier in the morning. So as lawyers, there is that gap that is lacking that we need to fill. And back to your question, why should businesses be interested in intra-African trade? Number one, I'll give you a basic one, which is similar tastes and preferences. I'll give you an example of maize. Maize is consumed in many forms in the African region. which is not which does not apply in other countries. So, meaning if you're dealing in exporting or selling maize, you're going to have a better market. You're going to because there are so many people that will want your produce. So you'll find that exports within the East African region are higher than, in relation to maize, are higher than with European markets. And then there are low market barriers, low tariff reduction, which leads to low prices, and to low prices and higher markets. Then the mutual proximity of African countries. The mutual proximity reduces the transport costs. If you have to sell a good to probably the European market, you pay a lot in transportation costs, which you will not pay if at all the infrastructure. I know we still have a problem with that transport and connectivity within the region itself. So that's still a challenge. And if this challenge is resolved, this mutual proximity will be advantageous because it will reduce the costs of transporting goods from one place to another. And then there's the issue of similar language and cultures. And this goes for textiles. If you're selling African related products, the African market, the intra-African trade will be very advantageous to you, among other things.
Thank you, Mabel. We're going to open up the discussion to the audience and we are going to take questions. Tony, you can help move the microphone. Please, people online, feel free to ask your questions in the chat. If you have any question for Mabel, David, Leila, and Ivan, this is the opportunity to ask. Maybe as we wait for that to happen, Ivan, Mabel has said that we still have some challenges. An example is infrastructure, and I know the Ugandan government is making efforts to ensure connectivity with like DRC. If we are to trade with a country like that, we need efficient roads, ease on the transportation. The question to you, Ivan, is what should be done to ensure that trade and custom procedures are more efficient, and what should be put in place to eliminate the non-tariff barriers to allow for a more efficient trade system?
Thank you very much. Everything is already in place. The laws are there. Uganda is a signatory to the member of the World Trade Organization. Uganda has, of course, because it's a member of the World Trade Organization, the Trade Facilitation Agreement is binding on it, which is a standard agreement on customs. URA has put in place all kinds of mechanisms in place. It is never really a question of the infrastructure of the laws. It's always a question of, even after taking those vows, is it about the vows or it's about the person? So if a person goes ahead and cheats with their partner, are you going to say that the vows had an issue? The vows are already there. They're fantastic. So for me, political will, as simple as that. Political will. Tanzania will, from the Ujamaa, those who did history, from the Ujamaa, history with Ujamaa will always be protectionist no matter what. It has its own, for example, customs online system. I think it's called it's Tanzania something. As everyone else has Asikuda, Tanzania has its own. Tanzania will always invoke variable geometry, special and differential treatment, which are mechanisms. Even the FCA recognizes them, that certain countries are allowed to develop at their own pace sometimes. And that is the problem with international trade law. International trade law has very interesting exceptions, which defeat its purpose in the very first place. That even when we have entered these arguments, there are always those principles that allow countries to drag their feet. And importantly, the politicians always be there. Because, for example, why is Kenya entering into bilateral agreements with the USA, with the UK and elsewhere? Of course, we had a very good judgment, I think, towards the end of last year, that declared that argument, one of the arguments, illegal for breaching the East African Community Treaty, because they're supposed to enter those arguments as a community, a customs union currently. So for me, everything is there. Mechanisms are being put in place. Of course, yes, we still have a few infrastructure problems as Africa, as a general problem, but it is always a question of the politics. The only reason, again, let me go back to the politics. Kenya is now allowing our poultry back into their market. Why? Mr. Ruto had promised under his Hustler manifesto, had promised to increase. I think something he promised, and it is in line with that. So there was a shortage of poultry in the country. So as a result, Uganda, because we have a lot of capacity and there's a lot of poultry chicken feed coming from Uganda, it was allowed into the market. So some of these are political. So another president will come and say, but no, these, of course, we have even an SPS protocol under the East African Community, but they will never invoke it. They will never invoke it. For example, last year when they banned the importation of our milk, for you to invoke an SPS mechanism, it's supposed to be scientific based, as Professor told you earlier. So we have all these mechanisms in place, all these treaties, all these wonderful protocols, but it is just the implementation and always the politics. Whenever a politician thinks this is not in line with their ideology or just to frustrate their neighbor, they'll come up with something. So I think that's my answer.
Thank you. Let me pass the microphone around, Tony.
My question is actually related to what Ivan has just been talking about. So there is this whole maze of rules, agreements, and treaties, and so on. But the one thing that kind of intrigues me is the enforceability of decisions that come from dispute resolution forums. For instance, WTO, and this question perhaps would be best answered by Professor Leila. So I'm just thinking, if I have a decision from the WTO dispute resolution mechanism regarding international trade, investment, how enforceable is that decision? Is there a sanctions regime that can be invoked to enforce these decisions? And again, why I'm asking this is we know that decisions that come from certain international forums are merely, some of them are merely, can I say academic? They are not really enforceable. For instance, some decisions from the ICJ are not easily enforceable, if at all. So my question is, how easy is it to achieve enforceability of these decisions? Because we see so many things happening, for instance, in this block of East African community, breaches of protocols that have been agreed upon by countries, and countries get away with it. So are there mechanisms we should be looking at that would be helpful in terms of enforceability? Thank you.
Thank you very much, David. That's a very interesting question and very important question, because as our colleagues were saying, there are a number of things in trade and investment which somehow defeats the purpose of the whole edifice, you know, super technical, so many rules and protocols and agreements, a number of decisions. I've just looked at the WTO website to see whether Uganda had, because I didn't remember, any dispute. Actually, you didn't have any WTO dispute, which in a way is good. You can come prepared. I think it relates to what I said before, you know, because of the importance of the country in general trade and global trade. Just to give you a comparison, China is a new member of the WTO, only 20 years. And already something like 23 dispute as a complainant, 49 as a respondent or defendant, it's the same, respondent. So 23 and 49 after 20 years of participation to the WTO, it's quite something. But look at the US, 124 dispute as a complainant, 157 as a respondent. It says a lot. It says a lot about who's doing what, who's trading where, and who's, you know, claiming and indeed active in dispute settlement. The good thing with WTO dispute settlement, and then I respond for investment, but the good thing with WTO dispute settlement is that to some extent they're relatively easy to enforce because they ask you to harmonize your system, to put your system into conformity with the WTO. It's not that you're going to be asked for compensation, you see, as in a private environment. You're asked to put your system into conformity with WTO rules. So basically to change your text, your laws. So obviously it comes with some sort of negotiation as well. Remember, in the back of our head, we have the idea that it's a diplomatic mechanism somehow, state, right? So there are plenty of negotiations between the states when a decision has been taken by the appellate body. And one of the reasons I think the US is blocking the mechanism at the moment is that they're not very happy with the Airbus Boeing case, for instance. Such a massive dispute between Europe and the US about the idea of subsidizing this type of industry, right? So bringing into conformity, which is less costly sometimes and easier to enforce than paying, a certain amount of money or okay. However, it comes with a lot of negotiation, and countries are smart. They play around with the system. Imagine the dispute has to do with subsidies. They may then play a bit with another area of trade to negotiate. Okay, I'm going to bring my system into conformity as far as subsidies are concerned in this given sector, but maybe you're going to give me a few concessions elsewhere, So there's always a negotiation element and a diplomatic element, really. As far as investment disputes are concerned, it's a completely different ballgame. You may have heard of very controversial decisions like the UCOS decision against Russia, or maybe a number of decisions against Argentina, or recently Spain, or even the Vattenfall case against Germany. We're talking about millions and sometimes billions asked to the state in reparation for breaches to the bilateral investment treaty or whatever international agreement. Are these disputes enforced? Is Russia really paying, I don't know how many millions? Is Germany really paying, I don't know how many millions, or maybe sometimes up to billions? I don't think so. There's not much transparency there, but I think most of the time, and I wish we had studies, but for reasons that you can imagine, because it's so highly political, we don't really have that many studies. I think, having talked to specialized lawyers, that most of these disputes are not really enforced. So your question was really important indeed. So there's a whole game there. There's a whole industry as well.
Thank you, Leila. There's another hand. If you have a question and you're online, please put it in the chat session and we shall read it out.
Perhaps I could also, first of all, just to make a comment, and I think it's very important, especially to Professor Leila and Council Ivan, building capacity right from the academia. So it's very interesting that now there's at least some specialized programs coming through. But I also wanted to ask David still a bit about what do we really gain from negotiating as a bloc? You have said this thing for us, negotiating as a bloc, and also alluded to by Professor Leila, but also like Councillor Joseph here has said, that we have big problems still even within the bloc. We don't want to trade fairly. So is it sort of a dilemma that we're able to negotiate effectively as a bloc, but then we cannot even resolve our own issues or even implement the terms of our own protocols? I don't know if that makes sense.
Thank you very much for the question. What do we get from negotiating as a bloc? I'll answer this as using the following example. When you have a group of ants, if there are 1 million ants, they can carry an elephant. So negotiating as a bloc, first of all, gives us more power and more credibility. And instead of having one person negotiating on behalf of an entire state, you have 10 people negotiating for the group. And you see, when you're negotiating for an entire group, your decisions are much more received than if you're negotiating individually. So, and usually you find that since we're integrating into one East Africa, you find that if you negotiate as Uganda and you get a different position from negotiating as Tanzania, then it becomes very difficult to implement such a decision. We faced a similar situation whereby Kenya negotiated an agreement with the UK for Brexit. And then East Africa was similarly trying to negotiate with the UK. And then already the UK Kenya agreement is in place. It has different subsidy arrangements, but then East Africa is also trying to negotiate for a better deal than what Kenya got. And then you see that kind of clashing. So it was agreed by the summit that every other negotiation shall be handled as a group, so that when we achieve something as a group, there is no dispute in how to nationalize such an arrangement. So it is much better if we negotiate as a group, because at the end of the day, we find that we are implementing a decision as East Africa instead of having each party negotiate separately. We have problems as a bloc, correct? But we are working hard to ensure that we have a smooth sailing. Kenya and Uganda are almost completing the standard gauge railway. We've had financing issues. We are now working well with Tanzania on the rice issue. The rice from Tanzania is no longer subjected to VAT. So these are problems. We have problems. We are growing as a community. Even in your household, every time you keep growing, you keep having problems. But how you solve problems is what makes you stronger.
Well, your question was it, isn't it paradoxical that we are engaged in all these trade negotiation and member and party to these agreements, and yet we don't trade much? Was it the question?
The question was, like Council had said, that we have serious problems even within the bloc in terms of implementing our own regional rules on trade. So I was just wondering that if we cannot implement our own rules, then how are we able to negotiate effectively as a bloc with bigger bodies? For example, not as state, but as a bloc.
To me, and I think I concur with what David just said. It's not necessarily a problem. I think it goes in parallel. That you have implementation problem doesn't mean that you can't negotiate as a bloc, because you're simply stronger as a bloc. But there's something I'd like you to notice, maybe, which I find really interesting. I'm going to use the example of China. China joined the World Trade Organization only 20 years ago, when it was very ready, actually, because it had 30 years or so of opening up to the world and trading with the world. So it took time to join the World Trade Organization when it was ready. It was a very long accession process because it had to put its economy and its rules, its law in compliance with a more capitalistic model. But, it came very prepared. What's paradoxical for a number of African countries is that they joined the system early on, when they were recently independent, not very prepared legally, and not very prepared in terms of trade, right? Because they were not trading much yet, and they're certainly not prepared legally speaking. So that's always been, I think, one of the paradoxical things with the African continent, is that you've taken part, right after independence in the 60s, 70s, 80s, to a number of international bodies, including trade and investment, while you were not ready for obvious reasons. While bigger countries like, for instance, China is a good example, was not even part, Another contradictory example is India. India joined all these organizations early on, very often as a founding member in the 40s, 50s, 60s, etc., and had to catch up. But it put the resources, because it's also a bigger country, it put the resources, and now it's very much leading in terms of negotiation. But you see, I think there's something to reflect upon. Joining certain organizations when you're not ready, and that's part of the criticism somehow against the African agreement. Are we really ready to embark into something that big, that ambitious, while we might not even be ready to trade and to have all these rules at a more local level? This being said, there are lots of programs for capacity building, and one of the ambition of the agreement is also that to build capacity. Really, I think our colleague has something to add up.
No, Professor, concluded your thoughts. Okay, just for me to add voice to my colleagues, I think it's down to the principles of a customs union. If you go to the GATT agreement, I think Article 24, and Professor will agree with me, a customs territory or a customs union is more or less a semi-country. Remember, you have a common external tariff. You've allowed market access each of the member states. You don't charge some goods. So it wouldn't make sense for you to go and agree on different tariffs when you're negotiating internationally or regionally away from your colleagues. So that is why the UK Kenya agreement was declared illegal or contravened the protocol of East African Community. Sorry, the Treaty of East African Community as per the ECJ last year. So it's just because of the fact that we're a customs union, we're a single customs territory. That is why we need to negotiate together. Very interestingly, the AfCFTA allows individual member states to enter into bilateral agreements individually, which is very interesting. But as long as it provides reciprocity to other member states of the AfCFTA, which is a major, it's going to be very interesting how it plays out when eventually things get running, but it is a very interesting concept.
Thank you, our panelists. And something interesting just came out of the discussion of how states are entering into some of these agreements when they are not actually ready. And a question just came in for you, Mabel. Why is the intra-African trade so low? And what are the general barriers to trade?
Why is intra-African trade so low? Number one is historical factors. Africa has been dealing in raw materials as opposed to manufactured or processed goods. And because of that, we get more goods from Europe and China than from African countries because we've been dealing in raw unprocessed goods. And the other reason is lack of information, like my colleague expounded on earlier. There is also poor infrastructure. There is no connectivity. For example, I'll give an example of Malawi. To export goods to Malawi, they'll have to go through France and then they'll get to Malawi. And yet we have the tripartite in place. The tripartite is the agreement that harmonizes standards between the East African Community, COMESA, and SADC. So you'll find that it is more expensive to ship goods to Malawi than getting them from China. So you get the China option because of the poor infrastructure that is in place. Lastly, I think it's trade financing. Majority of businesses in Africa are SMEs. Over 80% of the business in Africa are SMEs. And without trade financing, it is hard for businesses to engage in regional and international trade. And the last question was the trade barriers and what else? Okay, thank you very much.
Thank you for that. Government has looked at the implementation of SCFTA through cooperatives. We are utilizing cooperatives. Since time immemorial, Uganda has been stronger because of cooperatives. We've had coffee, but at one instance, these cooperative societies were shipping a lot of coffee than it is now. So we've adopted a cooperative method of approach. So that has been done through the parish development model. For the last 2 years, government has been releasing, including this this new budget that we're preparing. We are planning a 1.1 trillion budget for the parish development model. Now, the parish development model is specifically aimed at increasing production from the parish so that these cooperatives have the capacity to increase production at the lower level, bring the goods, whatever they've produced at the lower level, to the primary societies and the secondary societies and tertiary societies for export. So you can only export what you produce, and production must start from the bottom. So if you empower the person at the bottom with financing through the parish development model, then you'll have what to ship. And we are doing this and also strengthening. We've apportioned about 20 billion in the next financial year to enhance storage capacity. However, we've also seen private players coming into this space of enhancing storage, because our issues have been production and storage. So if you solve production, you also need to solve storage. Otherwise, how will you ship what is not properly stored? So we are utilizing the parish development model and the financing therein to encourage production at a lower level. To get from this subsistence farming, really, we need production from the lower level, and then we have what to ship to our neighbors under the SCFTA.
Thank you. Thank you for the presentations today. I think my question will go to David, especially. Despite all the protocols we put in place, like the East African Customs Union and all the other measures you've been talking about, we've seen countries like Kenya go out repeatedly to negotiate treaties bilaterally. Like they expressed their interest to negotiate the bilateral treaty with the US recently, and also the EP, the Union, East African, Kenya and European Union agreement and the Brexit agreement. And their reason is that Uganda or the other East African partner states are not participating or being more vigilant and like showing more interest in enforcing these treaties that are already in place, or even ratifying them and domesticating the same. So as Uganda and the Ministry of Trade, what are we doing to make more use of the treaties that are already in place, or to even practice them more, bring them more to the public awareness? Because like you've seen from the lawyers in this group, and maybe those who have subscribed, very few lawyers are actually aware of maybe what Uganda is doing or its part to play, or how they can build up their capacity to participate more, both in the East African community and also in the other East Economic Partnership agreements that we've negotiated out there. So my question is, how are we enforcing these economic partnership agreements more as the ministry? What mechanisms are we engaging to make these agreements more relatable, approachable in the instance of Uganda? But also in regard to the law, when Kenya went ahead and expressed the interest to negotiate the bilateral agreement with the US, it's Kenyans who had to go out of the way to sue their own country, yes, as East Africans. But I'm wondering, shouldn't this have been an initiative that came from Uganda or Tanzania or Rwanda? Why aren't we interested in pursuing this partnerships more and making them grow our country and the East African community at large?
Thank you very much for the question. It's true, we've had some weaknesses in the East African community in terms of negotiating these bilateral agreements. And Kenya, being a much more developed economy, has always wanted to further its economy. And for us, we've been a little more relaxed. That's correct as a matter of fact. However, after the East African Court of Justice last year declaring the Kenya UK EPA unconstitutional, I don't know whether they call it unconstitutional, but for lack of a better word, unconstitutional, because it didn't meet the ESC criteria of negotiation, it woke us up. But what are we actually doing? Why is Kenya negotiating alone as opposed to negotiating as East Africa? So it's true the weaknesses have been there. It is true we are now taking an active role in addressing these weaknesses. One of the ways we are doing this is we are now more engaging to the law society in case we have a weakness in negotiation that we need addressed. My learned friend Mebo has been of great assistance in this area. And since we've formed a cluster now, we are, I think we've done Uganda proud. So the challenges have been there. We are taking active steps to address them. And I can tell you, as a matter of fact, the Kenyans are not going to negotiate with the US on their own. We are now doing it as East Africa. So the court has stressed it as a matter of fact. The Secretariat has been informed that if any of these countries wants to negotiate, we must do it as a bloc. So the weaknesses have been there, but we are taking active steps to address them. Thank you very much.
Thank you, David. Our time is fast spent for this session. So we are going to just give a brief closing remarks, and we shall start with Ivan here. He had an additional comment on that, and then he will give us his final remarks. And then each of our panelists will give us their remarks, final remarks. Thank you.
Thank you very much, Agatha. I have a very radical view on that EPA. East Africa does not need it. It is one meant to destroy African integration, especially East African integration. And also it properly shows you the problems of bringing countries that are different levels of development together. Kenya has interests. AGOA is ending. They have a huge flower market in Europe, and they need that EPA ASAP. The rest of the countries have delayed to sign it because they think they need to study it further. Because one, you're bringing European goods in here, which are going to outcompete our products. Then you're sending our products and to the European market, which are majorly not value added and not be able to compete, as AGOA has shown us. So we don't need that EPA. Let's continue that ESC and AFCFTA and forget about those bilateral agreements. Thank you very much, Mebo and team and Agatha for organizing this session. And thank you very much, Uganda Law Society. I believe with this cluster being launched today, I think at last we can also get a bite of the pie. Ministry of Trade has been enjoying alone. We also want to be able to represent our country at the World Trade Organization and bring international trade and development to Uganda.
Thank you so much. Should I go? Yeah. Well, thank you very much, everybody. I found it very interesting that Kenya had to eventually say that an agreement it negotiated is eventually illegal and contradicts its own other international obligation. This is very funny, but anyway, you see the complexity of trade. So thank you for organizing this session. I'm pleased to see that you already have a few experts really. It showed in our discussion. It's fantastic to see that the government is very much ready to move on and build up capacity. And you have the internal resource with the cluster now forming, and you surely have more lawyers joining the cluster interested in growing this sort of practice. So thanks very much, everybody. It was very interesting, and you're going to see me for a bit more as I have an exercise for you.
I would like to thank the Uganda Law Society, KAA, and MESA Advocates for organizing this CLE and for creating an international law cluster. You don't know what you've done for the country, but you've created a pool of lawyers that we can consult. At least now we'll have better bargaining power at the international arena than we had in the past, because David alone may manage to negotiate on behalf of the country, but if I could consult this large pool of lawyers, I'd be more, or we would be more well equipped as a country to negotiate further. I'd like to thank everyone for the questions, and let's all believe in the ACFTA, because this is the future of Africa. Africa rests under the ACFTA. We are going to develop as a continent, and we shall not develop as a country on its own. The ACFTA creates a bigger market, and therein lies our future. Thank you.
Thank you very much. I'm also going to give vote of thanks to Uganda Law Society, the managing partner of KA, and Agatha. Thank you very much for supporting this event. Thank you very much to the Ministry of Trade. Sender, please tell the minister that we are grateful, and the permanent secretary for including us in their future plans, hopefully. My hope is that after this training and forming the cluster, lawyers shall be involved in national negotiations and other efforts in advancing the international trade agenda in this country. And you mentioned earlier about the 1 trillion that is going to be dedicated to the parish development model. My prayer is that lawyers shall be involved in the capacity building for the parish development model, and that a budget will be created for lawyers so that we have a space in this field. Thank you very much.
Again, a round of applause for our panelists. Thank you so much for being here with us, and I'll ask them to take their seats. The people online, the panel session has ended, and Leila has an exercise. We shall try and end on time as planned. She has a simple exercise.
Simple exercise,
that
absolutely.
She wants to
Agatha.
take us through.
So what we'll do, I planned 2 exercises, but we're running out of time. I'm sure you're a bit tired, and we want to have lunch as planned, and everybody's online must be a bit tired as well. So what we'll do is something extremely simple. We have been talking a lot about the African Continental Free Trade Area, and we haven't yet looked at the legal text. So let's do that together, and I have a few questions for you. So we're going to divide this room into 4 groups. I understand that online for you is slightly different. Online, just pick and choose the topic you prefer. And in the room, we'll work in groups. So I'd like to divide the room into 4 groups so that we look at the text of the African Continental Free Trade Area. So this text you find very easily online. You just go to the website of the African Continental Free Trade Area here. You go to resources and you go to legal text. So I don't know whether you can see that, but very easy to find online. You all have your laptops or your phone, African Continental Free Trade Area. You find the website, you go to resources and then legal text. And then here you find the English version. You have English, French, Arabic, and Portuguese. You find the English version of the legal text. You look at that. And while looking at that, I would like to have one group here looking at the general objectives of the agreement, general and specific objectives. So one group working on general and specific objective, one group working on principles and definition, one group working on dispute settlement, and one group working on exceptions. In doing that, you look at the agreement and at the protocols. Sorry, yeah, exactly. I was wondering whether I was right. You look at the agreement and the protocols, and I'm going to remind you the group. So one group is going to look at general objective and specific objective, another one at principles and definition, another one at dispute settlement, another one at exceptions. And to do so, you not only look at the agreement, but also the protocols, because as you're going to see, it's a long text which starts with the agreement, generally speaking. And then you go into details and you have a protocol on goods, on services, on dispute settlement, and so on and so forth. Do we agree? So we have maybe 15, 20 minutes to do that together. And then we reconvene and we share our thoughts and we'll come to concluding remarks. Okay? So I'm going to move around. and distribute the work in this particular room. For those of you who are online, you're free to choose a topic just for you to look at the text really. So I think this group here is going to look at general objective and specific objectives, this table. This table here in the middle, meaning we're merging two tables, is going to look at principles and definition. This table there in the back is going to look at dispute settlement. So we're trying to merge this table. And maybe people there in the back and people here are going to look together at exceptions. Is that okay? Yeah? Everybody has a topic and everybody's ready to work? Excellent. So I'm going to work around, help you look at the text, and it's 12:27. Let's say at 12:45-ish, we reconvene and share what we found in the text. Everybody, you found the text? That's fine? Yeah? So I'm going to come to see you. Hi, everyone. I know it's not very user-friendly, but if you found the text on the legal text, you have seen that you have a first part called agreement, and following up, if you scroll down, you have all the protocols, the one on goods, the one on services, the one on sanitary measures, the one on dispute settlement. So it's just the same document, but scrolling down at the bottom of it. Yeah, and I hope people online have also noticed that. Well, everyone here and online, shall we just take 5 to 7, 8 more minutes to wrap up? Because then I would like to have a discussion with you and we'll have to bring the session to a close. Same thing for everybody online. If you want to wrap up, and maybe if you have questions, feel free to use the chat box. We're here to respond to your questions, even if you're online. Do you need a few more minutes or are you ready, you think? A few more minutes? Amazing. Maybe 5 more minutes and then we wrap up. Okay, everyone, I think it's really time to wrap up because we have a lunch plan in 10 minutes. And I'm sure many of you are getting a bit tired of the whole morning. It's been quite intense. But what's really nice to see is that you are discussing at your tables, you are sharing ideas and information, which was also part of the exercise. Generally, when I teach and I train, I've trained many government officials and sometimes lawyers as well from the region, very often in Trapka, in Arusha, in Tanzania. I always use this method of group exercise because then we built up a rapport as well between us, and we have plenty of ideas. Today, we didn't have much time to do that, but in any case, that's a very good start. Right, so let's start with your group. You had to look at principles and objectives, general, specific. What do you think? What can you tell us?
Would you like us to tell you what we think about them? All right. So there are various objectives that have been set out and principles, of course, that involve creating a single market for goods, creating a liberalized market, free movement of capital, natural persons, and these have been enabled by the protocols on trade in goods, on trade in services, on rules and procedures. However, what probably stands out for me is that despite the fact that we've done a relation to the WTO that is quite similar, despite the fact that we have come up with very similar rules to the WTO, we've not come up with anything in specific that distinguishes the African Free Continental Agreement from the WTO. We have come up with rules that are talking about the reduction of tariffs, free movement of labor, equity in trade. However, there is no specific rules that apply to African governments in their state of development and export and industrialization and trade that would improve trade in the African states as Africa, not as trade in general. For example, I believe our protocols maybe could have done better to provide for more industrialization. Of course, we have articles that are providing for trainings and improvements of capacity building and all of that. But there is nothing that is catering for underdeveloped countries, because I think we are going to face the challenges that we are facing now, that there are more developed African states than others. And so there is nothing in the protocols that is bringing equity between the two states or enabling competition of the countries that are less developed from those that are more developed, or even improving the relatability and accessibility between the different African countries. So yes, maybe we allow free movement of labor, but if there is no protocol or any rules that are making it cheaper to move between the African states or more easier or accessible, I've also noticed that despite the fact that the objectives provide for inclusivity in gender equity, there is nothing in the protocols that is enabling that specifically. Because I've noticed that even in the WTO, we are shifting from just trading services to putting up rules to enable equity in gender and promote services trade for women and small and medium-sized entities, to build them and improve them. But our protocols, however nice they are not opening the trade up for women-based organizations or capacity building specifically for that. And yet studies show that women are the biggest people right now who are also engaging in trade and small and medium-sized enterprises that could be enabled by some of these protocols and new rules that are coming up. So things in relation to that, maybe my colleague could also say something.
My concern is on the protocol on free movement of goods and services, which affects general objectives A, C, B, and specific A and B. I think there needs to be more work done, more so on the mobility of the goods and services and the labor and capital. Because you'll find, I was telling my colleague here, you find that today it is cheaper to move from here to Dubai than it is to move by air, because that is an established infrastructure. It is more expensive to move from Entebbe to Arusha than it is from Entebbe to Dubai. They need to be more proactive and move more specific to certain areas that will enable the functionalization of the objectives vis-a-vis the protocols. Thank you.
Thank you. I think they've covered everything. To me, it's just heartwarming to see the progressive nature of the agreement. It recognizes the fact that we're not there yet, and it sets out, ways of how the countries will engage to be able to get to where they want to be. So I think, to me, really, that is extremely a plus. And I think that as long as we address the functional barriers, especially around infrastructure, maybe I have a bias because I'm a projects lawyer. I like to build roads, rail, and if you just look at Africa, you really realize, serious challenges around how you're going to move goods and services. Clearly, I mean, we'd have very competitive markets if we were trading, across borders and all that. But just the practicality of it is really what causes the challenge. So maybe as part of what we do, we should also try to figure out and drum up support around supporting enabling infrastructure.
Quite amazed by your group, I must say. You've done a lot of work in a short amount of time and you came up with excellent observations. You see, it's always interesting to look at the text, the legal text. I don't know whether you looked at the legal text of the agreement before. You did. Yeah, you didn't. That was your first time because it's not your area of work, right? Yeah, but that's excellent. And I particularly like all your remarks, the fact that there are lacking elements, but at the same time, it's in the making. It's flexible and it's going to evolve. That's the idea. And yet again, we've noticed, as you said clearly, that the Africanness of the agreement was somehow lacking, right? It's a bit a copy and pasted from general agreements that we could find everywhere in the world. And that's a pity because this is something we say for decades. And there was, there was the environment to produce something a bit more indigenous, so to speak. And it has not been done. For what reason? I have no idea. The negotiators were not keen or were not daring. But that's a pity. So if you could influence your relative, your respective, governments, whenever in a trade negotiation, they can, put their own mark to it. There's no reason why not. And also what you said was super interesting on, this sort of devils in the detail provisions. Absolutely. Amazing, everybody. Thank you so much. Now let's move to the next group. We have this big group here, which I think has worked very well as well. What can you tell us? Who would like to start first?
Okay, thank you. From our group, we mainly looked at the principles and we're not able to go to the negotiations, but looked at the principles. And some of the ones that stood out was in Article 5C about variable geometry. And the definition that we got for variable geometry is that it's an approach in regional integration which allows member states flexibility, but to also choose differentiated speed towards integration, which I think you had earlier talked about during the presentation that while we are so ambitious that we want to have Africa as a whole customs area, we are cognizant of the fact that not all countries or economies in Africa are at the same stage. So we'll allow the different countries. Of course, we are all moving towards the same direction, but then some countries will do it faster than others, and that's okay. So, and I think that was our explanation that we got as a group. The other one was about flexibility, the principle of flexibility and special and differentiated treatment. This was also a bit related, but the variance from the earlier principle was that flexibility works in such a way that where even while you've agreed on certain principles, for example, there should be instances where you should be flexible as countries to allow, I think the example that we gave for this principle was maybe we've agreed to trade with Kenya in, let's say, maize, but then Kenya has an issue with maybe something that's in our maize. And so we should be able to allow, that they are not going to accept our maize because of that something that's in our maize. I think that was the explanation that we had. I'll pass on the mic for the other principles that we talked about.
Thank you. The other principles we had, sorry. Okay. We have transparency and disclosure of information, which has to be put out by the different state parties in every trade agreement they're going to carry out. And then we have a preservation of the acquis. Acquis is a new term, I think. Acquis. Yeah. Yes, okay, yes. And basically that one means that you build on what is already existing within the 8 regional recs. And when you look at the definition, under the definition clause under Article 1, it gives you the different recs on the African bloc. But then even when you look at the principles, they are not mainly defined under in the definitions, they're not defined. So you really have to dig deep and find out what they mean. But then when you look further into the definition, you see it relates to the GATT and to who, meaning that almost all what we have is within those 2 agreements. And then we might have also national treatment, looking at what a country produces better for themselves. Then we have reciprocity. We didn't look at all the principles in general. Yes.
Is there someone else who would like to add?
I think the first principle, I think, is where we had some bit of back and forth, and probably that's why we didn't complete going through all the principles. And it's the one that was talking about the fact that it will be driven by member states of the African Union. So we're going about talking about the fact that not all members of the African Union have signed up to this treaty. So that, there's no way, depending on international law, there's no way that treaty can affect me if I've not signed up because of that principle of sovereignty. So it looked like it was redundant. There's no way it's going to apply to all members unless those members have signed up to the treaty and be members of the after. Yeah.
Excellent. Excellent again. Yes.
Thank you. One of the principles that also stood out was REC's free trade areas as building blocks for the AFCFTA. So this is important because it recognized that I think all African countries are already member states to different markets and different trade areas. So I think the intention was not to create a clash or kind of a contradiction between in circumstances where a state wants to negotiate with another state within the AFCFTA, but it's not a member, for instance, of COMESA. So yes, so the states, they have to comply with both. So I don't know which one would take priority, but I think that was the intention, that there shouldn't be a clash because it recognized the existence of earlier agreements that were established before it. Yeah.
So the complementarity somehow and the flexibility, and yet a few sort of gray areas as you've identified very well in the principle. Any other remarks in your group? No? But again, fantastic work in only 15 minutes. So thank you so much. We move to the dispute settlement table. So how do we settle disputes in this agreement?
Thank you very much. It starts with a request for consultations, which people who are practitioners here is like a mediation process. If the dispute can be resolved at consultation stage, then it is resolved. But if it's not, if one is not satisfied, if the complainant is not satisfied, they can move to the DSB, which is a dispute settlement body, and request for a panel in writing. Well, the panel, after the panel determines the matter, they come up with a report, which is adopted by the member states. But still, if one is not satisfied or one of the parties is not satisfied, they can go to the appellate body, and from there you get a final determination, which is not appealable. But however, as far as the DSB is concerned, one has the option of either choosing to go to the DSB or arbitration. Yes, similar to the World Trade Organization. Well, we have not seen the protocol on investment yet. And it will be interesting to see what it envisages, what kind of dispute settlement mechanism it envisages. There's something called the Pan-African Investment Code, which had attempted to sort of, but well, it's just a code, it's not really binding. Maybe let's wait for investment protocol and see what it will say about that. But rumor has it that they're going to bring ICDS to be resolved through the DSB or something. I don't know, we shall no longer have to go to the World Bank or Washington.
Okay, Ivan has given a summary, but what we have also noted generally is the time frames. It's interesting that there's not a lot of time allocated to settle these disputes. I think maybe the idea is to have the process go on expeditiously, so you find that maybe filing a response 10 days, maximum 30 days. So I think that is something that we think is really important if we're to have a effective dispute resolution.
But importantly, and Professor, following up from his comment, it is a question to you. What do you think about those timelines? Because again, from practicing in the regional courts here, there's something called the East African Court of Justice that has a very strict timeline of 60 days. 60 days. And many of we have suffered as lawyers because clients, because of the politics around, usually will say, the minister is trying to resolve this issue, so let's persuade. Depending the 60 days have elapsed and you cannot file a reference of the ESCJ.
Was copied and pasted from the WTO. If you look at the WTO dispute settlement mechanism, you have also quite strict timings. So you have to this and that in 30 days, in 60 days, and it works. It works because disputes are settled within the WTO system within a year and a half, 2 years. What you said, sorry. I don't think so, because yeah, of course. No, I don't think so, because you have the phase of consultation before, which is compulsory. So you prepare your case within the consultation. This being said, whether it hampers justice or not, depends on who's involved, right? And we go back to capacity building. If you have a country which is super prepared, has prepared the case as a complainant for a long time, consultation, for the respondent, if the respondent is maybe less prepared, then it might well be, yeah. It is state to state, exactly. Thank you so much. Anything else in this group? No? Do we have any questions or comments in the room? Not really. In this case, I think we have to bring our session to a close, and I'm going to hand over to Agatha.
Thanks everybody for participating in the exercise. Let's give ourselves a hand of applause. Thank you for braving it to the very end. I would like to thank the Uganda Law Society for the opportunity, and for all our participants for coming, our participants online. Thank you for attending the training, and we look forward to further engagements. Like the president said, this is just a foundation and we are going to build onto it. Please, this is just a call to re-echo the president's words. The cluster is going to be up and running. An email shall be sent to any person who wants to be part of the cluster to join. And lunch is served. It's served at the restaurant. When you go down on your right, Doreen Uganda Law Society is going to give them the vouchers. Please give them the coupons. And if there's no other question, I would like to ask a volunteer for a closing prayer. Mabel, do you have anything to say?
Apart from giving a vote of thanks, I don't think I have anything else. Thank you very much for sparing your time and money to be part of this club. Please clap for yourselves and be part of this event. Thank you very much to our keynote presenter, Professor Leila, and your team. They flew in all the way from the UK just to be part of this. So thank you very much. And I'm very hopeful that after this session, international trade law is not going to be the same, because now we're going to have the backing of all the lawyers. If you haven't registered for your CLE points, please register. Do not leave without registering. I've noticed only around 15 people have registered, and yet we are more than that. Thank you very much. And with that, I think we're going to say a short prayer and then close the session.
Okay, so how the registration, you just need to scan this QR code and then you register. All right, Philip, please, a closing prayer.
Thank you very much. I'm Philip Monabi, the first deputy chair of the Uganda Law Society Health and Benevolent Fund. It is an incoming project because we realize there is too much disease and suffering among lawyers. So it is a committee that has been set up. We shall soon be launching. It's a good product. Let me pray for you, people. We can number ourselves. Heavenly Father, we thank you for this session. It has been a wonderful one. We thank you for the guidance of the facilitators, the professor we've been with, the attendance and membership that has been both physical and online. We thank you for gracing us with the preparation of the organizers, Agatha here. And we also thank for the mercy that you shall put on the launch of the cluster, and bless it with so many opportunities that we can benefit from through networking and capacity building. Thank you.
Thank you again for coming. We are going to have a networking lunch. You go down the stairs and then on your right. But in a special way, Tony, please, let's appreciate Tony. Tony introduced me to Professor Leila. So Professor Leila wouldn't be here without Tony's efforts. Thank you, Tony. Don't be shy. He's one of our own and works with Leila. And Leila, you didn't introduce your colleague.
Thank you so much, Agatha. That's what I wanted to say as well. I wanted to thank you all. We've said that already, for being so attentive and engaging. You've been a really nice group to work on. I hope we work together in the future, either, in lawyer capacity or in a training like that to go deeper into a number of issues. That'd be really interesting. I'd like to thank again the Law Society of Uganda, its president, its vice president, Agatha Emembo, and obviously my team, starting with Tony, because Tony Kirabira has been the one leading this initiative and introducing me to Agatha. And so that's the source of the creation of this training. And I'd like to thank my colleague, Dr. Rowan, who's working with me for years and who's in charge of communication and media strategy, and has been supportive in the organization of this training and communication about it. Without further ado, I think we have to go to lunch. Thank you, everybody.
Thank you. Please, let's take a group photo. Let's take a group photo right here. A group photo. Please come for a group photo. Sorry to the people online. Yeah.
I need a little time away. I heard her say for me to say I'm sorry. I just want you to stay. After all that we've been through, I will make it up to you. I promise to. And after all that's been said and done, you're just the part of me you can't let go. Couldn't stand to be